Good morning. Craig Haynes.
Minu Lee.
Denise Klein.
Tom McCormick.
Charles Till.
And Ms. Dottie, you want to?
Good morning, everyone. I'm Alice Tejada, a Senior Associate City Attorney on behalf of the city.
Good morning. Molly Gross, Associate City Attorney on behalf of the city.
Good morning. Karina Lemons on behalf of the employee petitioner.
Thank you. And so the order of business today is that we're going to start, the city has filed a motion to dismiss. We'll hear that first, and then, of course, a response from petitioner, and then depending on what happens with that, we'll proceed with the next part of the hearing. So if the city wants to proceed with the motion.
Thank you, Chair Klein. Good morning, and may it please the Commission. As you heard, my name is Molly Gross, and I, along with my co-counsel, Alice Tejada, represent the city of Raleigh in petitioner's appeal today. As you know, the city filed a partial motion to dismiss the portion of petitioner's claims related to discrimination, disparate treatment, and whistleblower termination. The plain language of Section 5 of the Civil Service Act supports the city's motion. The city argues that petitioner's claims should be dismissed for two reasons. First, he has failed to allege a violation of a specific city policy directly contrary to the Civil Service Act, Section 5. And second, even if he had alleged a policy violation, he has failed to exhaust his administrative remedies, and his appeal is not right before the Commission. By way of background, petitioner was terminated from his City of Raleigh employment. And per city policy, petitioner was issued a pre-termination notice, participated in a pre-termination hearing, was issued a notice of termination, appealed that termination to the department director, was heard on that appeal by the department director, was issued an appeal response upholding the termination, appealed to the assistant city manager, who also upheld the termination. As to the first reason for dismissal, petitioner did not provide an alleged violation of city policy. The simple issue here is the plain language of Section 5 of the Civil Service Act, which states, "The Civil Service Commission shall act as an appeal board to hear all appeals of employees regarding violation of city policy." The Civil Service Commission is not a court of general jurisdiction and is not a court of equity. The Commission has limited and clearly delineated jurisdiction to hear appeals of employees regarding violations of city policies. The NC Court of Appeals has previously held in City of Raleigh versus Stell and Matter of Altman, copies of which have been provided, on areas in which the Commission has no jurisdiction. Just as those cases held the Commission lacks jurisdiction, jurisdiction is also lacking here. As to the second reason for dismissal, even if petitioner had alleged a policy violation, he has failed to exhaust his administrative remedies under that policy. The plain language of the Civil Service Act states, "The Commission shall have no jurisdiction to hear an appeal until all administrative remedies have been exhausted pursuant to the city's established grievance procedures." City Policy 100-20, Discrimination and Harassment Prevention, states, "The employee must cooperate during any investigation of alleged discrimination. Most importantly, at the conclusion of that investigation, contemplated in 100-20, employees have an avenue to appeal under City Policy 300-18, Administration of Grievances." However, in the first instance, petitioner failed to cooperate with the investigation under 100-20. The bank's law firm was hired by the city after receiving petitioner's June 3, 2024 correspondence to investigate his allegations of discrimination. Investigator McCarthy from the bank's law firm contacted petitioner through his attorney to request an interview with him, but petitioner would not speak with Investigator McCarthy without his attorney present. Investigator McCarthy confirmed this in her affidavit, which is Respondent's Exhibit 3 in the motion to dismiss. Investigator McCarthy also confirmed that petitioner did not provide her with any written information or details regarding his discrimination allegation. Petitioner has not been charged with a crime and has no right to counsel at different stages of internal city appeals processes. That investigation process is not a legal process, but an administrative one. The city attorneys do not make appearances during those investigations. Even if petitioner had concerns on the process, he failed to raise those concerns throughout. Because petitioner failed to cooperate with the investigation of his allegation, he failed to exhaust his administrative remedies under City Policy 100-20. In petitioner's response to the city's motion to dismiss, petitioner argued due process. As the commission knows, this commission is an administrative body and cannot hear constitutional issues. Petitioner is free to preserve that issue for a later appeal, but this setting is not the place. The Court of Appeals in Johnston v. Gaston County noted that constitutional claims will not be acted upon in administrative tribunals. Even if the commission could entertain that argument, under Souls v. City of Raleigh Civil Service Commission, there is no property interest in City of Raleigh employment. Petitioner is misreading the case and has stated the opposite of the holding in that case, which holds there is no property interest. Petitioner failed to allege violation of a specific city policy, and even assuming he did allege a policy violation, he did not exhaust his administrative remedies under that policy. For those reasons, the city respectfully requests the commission grant its partial motion to dismiss. Thank you.
Yes, we filed a response, which should be a copy. Did you all have a copy of the petitioner's response? Okay, and if you've, I don't know if you've had an opportunity.
It was not provided in the city's materials.
Okay, it's a part of the court record.
I can make extra copies, but the ones which sent to you last.
Yeah, we sent them, there may be a need for extra copies.
Okay, it's a part of the court record, or the file that was filed with the clerk. So let me first say that the first time that we heard of this motion was approximately a week. Well, we did hear about it during the pre-hearing conference, but it was filed about a week ago. And we filed our response on this Monday. So under Rule 12 of the Rules of Civil Procedure, lack of jurisdiction over subject matter is an affirmative defense, and it must be raised either in a motion before the responsive pleading or in the responsive pleading. And so it was not included in the city's response. Also, as part of the file, the record, is the city's response that it filed back in October the 25th of 2024. The city has attached a copy of Mr. Juarez's appeal, and in his appeal, he does state that the grounds, and he filed his appeal on October the 10th of 2024, that the grounds for his appeal was dismissal without justification, discrimination on the basis of race, desperate discipline, wrongful termination, violation of public policy, whistleblower termination. So as of October of 2024, the city was placed on notice that Mr. Juarez had discrimination claims. If it felt that he was not exhausting his administrative remedies, if it felt that he could not bring those claims forward in this process, that should have been raised months ago, not, 7 months later, when we're here for our hearing. I laid out the statute. I think what the city is trying to do is circumvent state statute, okay? And so if you look at, I outlined this in my response. So there's a couple of things. The Raleigh Civil Service Act says that the employee has the right to appeal a complaint that is subject to the commission's authority through the established city grievance procedure, that decision to the Civil Service Commission, okay? And then the requirements for the request of hearing are set out in that statute. Nowhere in the statute does it say that the employee must cite the actual policy number that the city has violated. And the requirements are there's 7 requirements that needs to be on that request for hearing. And that is, number 1, the name, address, and telephone number of the person on whose behalf the request is made. 2, the position held or applied for by the employee. 3, the number of years the employee has been continuously employed by the city. 4, the name of the department against whom the complaint is being brought. 5, the nature of the complaint, e.g. racial discrimination and promotion, dismissal without justifiable cause, etc. That is in the statute. Number 6, a concise statement of the facts necessary to an understanding of the situation upon which the complaint is based. Number 7, a statement of the relief of the relief desired. And if you look at the exhibit of Mr. Juarez's petition, his request for hearing, it includes not only the grounds that I read off, but it also includes in there a timeline and list of specific things that occurred. So Mr. Juarez has met his burden under the statute he's exhausted his administrative remedies. This is a part of that. We are in that process right now. So an investigation is not a part of that. There was an investigation, and that investigation is what led to Mr. Juarez's suspension. He was placed on administrative leave. It led to his suspension and ultimately his termination, for which he appealed. So there was an investigation conducted by the city, which he did cooperate with. It wasn't until, I said it was the affidavit, an attorney that was retained by the city to do an investigation and further into his discrimination claims, that he had already retained an attorney, already had counsel, and as you know, cannot speak with a person that is represented by counsel without counsel being present. We asserted that right, and now somehow it's a problem, and he hasn't exhausted his administrative remedies. There was no request for written materials. It simply was, if we can't talk to your client without you, then we can't talk to your client without you. The end. So I think here there's a couple of things that we also want to look at. There were some cases that the city sent over in regards to their claims regarding administrative remedies. And I think it's important to note that in those cases, let me just pull those up. In the matter of Altman, the reason why the court held that Mr. Altman did not exhaust his administrative remedies is because he was a captain in the Raleigh Fire Department, and that particular position is exempt from the Civil Service Act. The position that my client held was not exempt, and so this case did not apply in terms of the rationale for the court's holding. The other case that they presented, Johnston v. Gaston County, again, it's a similar situation. In that case, I believe this is, I'm sorry, not that one. I'll come back to that one. City of Raleigh v. Stell, Captain James Stell was a police department officer, and he appealed his decision regarding his promotion to the rank of major. However, the position of major, again, is exempt from the Civil Service Act. So that's why the court held that he did not exhaust his administrative remedies, because he could not come before. He didn't even have standing to come before the Raleigh, or before the Civil Service Commission. So I think there's a distinction there, and I think that the city's trying to take a rule and apply it to a set of facts that it wasn't designed for. In this other case, the Johnston versus Gaston County, the issue that they were dealing with was a property issue, was dealing with taxes, which again is not something that can be reviewed by that particular administrative body. And so again, they were trying to get a judicial review with the Superior Court, and they tried to appeal to the North Carolina Property Tax Commission. But ultimately, the court held that they emphasized that the plaintiffs had alternative administrative review options, such as seeking judicial review directly in Superior District Court after paying the taxes and bringing a suit for recovery. However, the method that they were trying to go through was not the proper venue for that. And we're not dealing with property tax, and we're not dealing with the North Carolina Property Tax Commission. We're dealing with the Raleigh Civil Service Commission and the Raleigh Civil Service Act. And so we are governed under that and not under simply just a narrow, limited policy that might say, if there's an investigation, go to the investigation. Well, he did. He participated in the investigation. He didn't refuse to participate in the investigation for discrimination. It was a situation where the attorney wanted to speak with him without his attorney present, and he was represented by counsel. I'm happy to answer any additional questions that you all may have.
Thank you. Is there a response? And then I'll allow the commissioners to ask questions if there are questions.
Yes, Chair Klein, thank you. As for the subject matter jurisdiction component that petitioner alleged, subject matter can be raised at any time during the hearing, even during the appeals process, and also can be raised by the commission. In terms of allegations of city policy, the city still needs to know which policy is alleged to be violated. We're not asking for technicalities, just asking to know which policy was violated. Using the word discrimination does not tell us which policy was being violated here. Also, in petitioner's timeline that he attached that Ms. Lemons referenced, there are no facts in that timeline pertinent to the discrimination allegations, and the city did note that in its departmental response. Moving on to the investigation piece of it, the city would like to reiterate that the investigations under 100-20 are not legal proceedings, and certainly the city attorneys may not speak to petitioner, but Ms. McCarthy was an outside investigator hired by the city and was a third party. Also, petitioner never raised this issue throughout the entire process to anyone, even at the assistant city manager level, Mr. Evan Raleigh. And moving to the cases that were cited and provided to you all, sorry, I know there's a lot of paper, but while it was not directly analogous to the positions, the cases stated there was no jurisdiction because those positions were exempt from the Civil Service Act, the remaining point is still the same. The result is the same in that the Civil Service Commission cannot hear certain things, and it's clearly delineated in Civil Service Act Section 5 what the commission has jurisdiction to hear. Also, in the Johnston versus Gaston County case, the Court of Appeals stated, and is highlighted in that case, constitutional claims will not be acted upon by administrative tribunals. That's all that I have in response. Thank you.
Thank you. Do commissioners have comments or questions?
And actually, could I respond to that? So it's important to note that the scope of the hearing is those issues that are raised in the request for hearing, and that's under Section 7D of the Raleigh Civil Service Act. The burden of proof is on the employee to prove the action taken against him was unjustified. If the employee alleges discrimination in the action taken, then the employee must present sufficient evidence to establish by the greater weight of evidence that the city did discriminate against him. And that's Section 7E, and that's regards to the hearing itself. the burden is on the employee, not on the city. And so the investigation that they wanted to conduct with the bank's law firm was them trying to, I guess, cover themselves or help defend their case against Mr. Juarez. It wasn't something that Mr. Juarez had actually requested. And again, he would have gladly participated in that had he been allowed to have his attorney present during the questioning.
Thank you. Commissioners, do you have comments or questions?
Yeah, well, thank you both for your presentations on this matter. But for the city attorneys, from what I can tell, obviously the city administrative excuse me, the city administrative policy 100-20 definitely requires employees to cooperate during these investigations, but I also don't necessarily see where it definitively clarifies that counsel cannot be present during the process. Is there any way that you could point to within that policy that states such?
So 100-20 allows for an appeal of a decision under 100-20, and that is where it states the city manager's office will be responsible for determining the proper avenue of appeal. And that proper avenue of appeal is under 300-18, another city policy. And in that policy, it delineates different parties who can be present at these investigations. And in specifically section 4.4.1 of 300-18, it says that during those meetings, the grievance will include only the employee representative of the HR department and appropriate city officials, supervisors, or employees as determined by the official hearing that grievance. So not included in that list is the attorney of the employee. Hopefully that answers your question, but happy to clarify.
Yeah, absolutely. Thank you. And also, I had one more question. So the when it comes to the demotion for partial dismissal, is the city motioning to dismiss on all of the matters except for dismissal without justification? Is that a correct assumption?
Yes, that is correct.
And as the petitioner's counsel also noted, the request for administrative hearing application itself doesn't seem to direct applicants to write a specific policy violation. All I can see from that application is as the petitioner's counsel stated, the name of employee, name of attorney representing employee, but just anything that seems similar to what is being claimed, it seems to be just the nature of the complaint, which doesn't warrant the applicants to cite a specific policy violation.
Yes, petitioner is represented by counsel, and Section 5 of the Civil Service Act is clear in that it specifically says that the commission has jurisdiction over specific city policies. Thank you.
Thank you. But I guess my ultimate question is sort of, where does it say that the petitioner must cite a specific policy violation that the city made?
Again, just going back to the plain language of Section 5, it does state that the commission has jurisdiction to hear employees regarding violation of city policy. And as for the form that petitioners must fill out, the commission is free to change that form to make it more clear. But as it stands, that's what Section 5 of the Civil Service Act says.
Okay, thank you so much.
I'm relatively new to the commission, but I've read the general statutes, I've read the bylaws of the commission, and nowhere did I see the word specific adjacent to the phrase city policy. What have I missed?
While the word specific is not in there, the city needs to be put on notice as to what the specific violation is to have the opportunity to defend itself effectively. And also, I will reiterate that the failure to allege specific violation of city policy is only the first reason that the commission should dismiss this. Even if he had alleged a specific policy violation, he still failed to exhaust administrative remedies.
Follow-up question, is it normative for the city when it investigates something to hire an attorney to conduct the investigation?
It depends on the workload of HR at that time that comes in.
Would you not think that if the city hired an attorney, not a private investigator, not a human resources consultant, but specifically an attorney, that there is a reasonable response on the part of the defendant that this is a quasi-judicial proceeding?
That's just the norm of the city to hire an outside third-party investigator.
Okay. One more
Law firm.
question. Has this issue of employee legal representation during an investigation conducted by an attorney who was hired and paid by the city, has this question ever been adjudicated before?
I'm not aware of that.
All right, thank you.
I do have one question, and it's not in the record, and you may not know the answer, but when the Banks Law Firm was hired, were they hired as counsel for the city or just in the role of fact-finding?
Just in the role of a third-party neutral investigator.
Okay. Any other questions? Any other comments?
Just a couple of questions for the petitioner's counsel. Obviously the city's attorney is claiming that there's no specific policy violation that the petitioner is pointing to. Can counsel right now point to a specific policy violation?
Absolutely. In our response, we cited that, well, actually, the city cited it 100-20, also 300-18, that's the policy that we're operating under right now. And then also under it is actually section, I cited this in here in my response. In the Raleigh Civil Service Act, there's a specific section that it refers to. Let me pull that up. And I cited that in my response as well. Section 9 of the Raleigh Civil Service Act. It prohibits discrimination under Section 9. In addition to the policies that I just cited.
Okay. I guess follow up to that. So when during the administrative investigation process, did the city ever explicitly notify that failure to oblige or refusal to participate in that third-party investigation would be treated as a failure to exhaust all administrative remedies? Or?
No, I believe they attached a copy of the correspondence. There's nothing in there indicating that they did not inform us of that. It's my understanding that they did conduct an investigation. We just didn't receive any results of that.
And would it be the city's obligation to notify the petitioner and petitioner's counsel that failure to or refusal to comply with the investigation process would lead to a lack of a failure to exhaust all administrative remedies?
Again, that is stated in the plain language of Civil Service Act, Section 5, that there's no jurisdiction for failure to exhaust administrative remedies. Also, petitioner was given a copy of 300-18, which states that as well. And in Investigator McCarthy's affidavit as Exhibit 3 to the city's motion, paragraph 9 states that Investigator McCarthy confirmed with the city that petitioner did not provide information or details regarding his race discrimination allegation to Assistant City Manager Evan Raleigh or Kimberly McCrae, Senior HR VP at the time. So there were multiple avenues for petitioner to comply with the investigation, whoever he wanted to present that information to, and it was not presented at any stage during this process. And again, in his appeal, he did not mention any facts other than the word discrimination.
Right, and it is up to the petitioner or it is expected of the petitioner to know that failure to comply with this process would lead to that lack of administrative remedies or exhausting of that?
Correct.
Okay, thank you.
I do have one question for you, Ms. Lemons. On Exhibit 1, the petition, there's identified dismissal without justification, discrimination on the basis of race, and you've identified a city policy with regard to that. There's also identified wrongful termination in violation of public policy and whistleblower termination. Are there city policies that you are citing with regard to those latter two claims?
So the wrongful termination in violation of public policy is a state tort, which we removed from the issues for this hearing. So that's not an issue for the hearing. In terms of the whistleblower termination, that's simply just another way of saying retaliation. And that is also in the Raleigh Civil Service Act as well.
Okay. All right. Any other comments or questions?
Sorry, one follow-up to that. So whistleblower versus retaliation, I feel like they're two very different things. Could you help make the clarification between the two?
So under North Carolina statute in regards to state employees, they specifically identify it as whistleblower. And that's when an employee contests any type of violation of policy or law or anything like that, and they get retaliated against, so or adverse employment action happens. We don't have that language when it comes to the Raleigh Civil Service Act. The language is used as retaliation.
Thank you.
All right, hearing no further questions, what's the spirit of the commissioners in terms of this motion? Before we vote.
To clarify, if the motion is granted, what is left for us to consider today?
Can you answer that, Ms. Gross?
Whether the dismissal was unjustified.
Any other questions or comments?
No, thank you.
Oh, I'm sorry.
Oh.
I was referring to the commissioners. I was looking directly at you, so I do understand why you responded.
Just wanted to be sure.
All right, are we ready for a vote? Okay. The city's motion to dismiss is before us. All of those in favor of granting the city's motion to dismiss, and it's a limited motion to dismiss, say aye. Aye. I mean, okay, so that's 3-4. Yeah. Did you have a vote? Okay. All right, so I think we need 4 votes, and as a result, and so do you want to weigh in on your vote, sir?
Yeah, I vote to deny the petition.
Okay, all right.
Would it be in order of this commission to change the motion to just dismissal without justification and discrimination on the basis of race? Or would the commission have to reject the city's motion first and then consider a new motion?
I'm sorry, I'm not sure we understand the question, but essentially, the motion that is before you is to dismiss the issue of discrimination and the issue of the whistleblower for lack of stating a city policy, giving the city notice. And then the only issue would be deciding whether the city was unjustified in the termination of the petitioner. That's the only motion before
Got it.
the commission.
Right. Okay. I guess my question is more so for Madam Chair then.
So the only motion before us is the motion that we have and that has
Right.
been responded to. And so that's the motion we have to vote on.
Okay. And if we were to reject this motion, would it be in order for any of the commissioners to offer a alternative motion?
No.
Okay. Got
Yeah,
it.
it's the city's job to offer.
Right. Right.
Yeah.
Okay. Wonderful.
Just voted anyway.
Yeah.
Yeah, we did just vote.
Yeah.
so,
Thank you.
Yeah. So the city has voted to confirm and allow the motion to dismiss. And so we'll proceed now to the remaining portion of the hearing, which is the, whether or not,
And I want to clarify to make sure who were the four that voted in favor?
in favor, these four.
Thank you.
Yes. Yeah. And so now we'll proceed to hear the evidence on the remaining portion of the appeal, which is whether or not the city was unjustified.
Thank you.
And now, now, Ms. Lemons, you go first. So if you want to make your, what we'll do next is inform, in terms of the protocol, we'll hear opening statements first from the petitioner and then from the city, and then, Ms. Lemons, you'll present your evidence.
And I had given a heads up that I would be asking that the witnesses be sequestered. We have some witnesses, I know that there's quite a few documents that the city has, so I imagine they may take some time with Mr. Juarez. He's my first witness, and so wanted to make sure that it was okay if we could release the one witness that is here and have them be on standby, but also that the witnesses be sequestered.
Does the city have a view on that?
Yes, Your Honor. So under Rule 615, the sequestration rule of evidence,
I'm sorry, what are you citing?
Rule 615, exclusion of witnesses for the, I believe we have a copy of that too. Parties who the rule does not authorize exclusion of include an officer or employee of a party that is not a natural person designated as its representative by its attorney. And so in this case, we've got the assistant city manager, the department director, and the assistant department director of housing and neighborhoods, who are all city officials who need to hear from the case from the petitioner in order to be able to present a defense. They're not just witnesses, they're the party, and they have a right to be here.
So one question I have for you, Mr. Hata, is it your contention that the North Carolina rules of evidence are applicable here?
Yes, I believe if you go to section, can you pass me? Section 7 of the Civil Service Act, it says that we can use the rules of the general courts of justice, and also the rules of evidence are under the State Administrative Procedures Act, which references, that act references us back to the general courts for their rules of evidence.
And may I also clarify, are you opposing the sequestration of not only of all the witnesses, or are you making an exception for the party witnesses?
If
I asked that badly, but you
If
understand
Ms.
the point.
Lemons would like to have her witnesses who are not parties sequestered, we don't object to that. However, we are objecting to our party witnesses from being sequestered.
Ms. Lemons, are you asking to have the party witnesses sequestered as well?
If the city's witnesses are not going to be sequestered, then there would be no need for ours to be sequestered. However, we are requesting that all the witnesses, so it's not going to be one or the other, it's going to be all of the witnesses. And I do understand that the employees that are here for the city, they are witnesses as well as they're the party that my client is complaining of. Additionally, we do have another witness that I would like to address the terms, I guess, of her testimony, but outside of the presence of the witnesses, just with the attorneys. And so I guess it would be approaching the bench, if we on particularly one of our witnesses. So that's one of the main reasons for my request for them being sequestered, but I also want the witnesses to testify based upon their own independent knowledge and not based upon co-signing on something someone else said.
So I'm not sure that, and I just want to go ahead and respond.
Well, this is a public hearing under the Open Meetings Act, and there is no ability to have secret testimony. And based on the list of witnesses, I'm not sure that they're going to be necessary based on the ruling dismissing the discrimination aspect. Other than Mr. Gray, who was listed as a witness, none of the other witnesses actually have any personal knowledge or involvement with the termination and the facts that surrounded it. So, you know, if this witness, and I'm not sure which one it is, but any witnesses, any of the witnesses who are female witnesses anyway, are not supervisors, would not have had any involvement, were not witnesses to the investigation that led to the termination. And so I'm not even sure, you know, if somebody gets on the stand and wants to talk about discrimination, that's irrelevant at this point.
All right, the commission has before it a motion to sequester certain witnesses. What say the commissioners?
Well, I don't think we should allow that. I mean, it is indeed a public meeting. And treat it that way.
Okay, any other comments?
Tom, please speak into the microphone, speak up, I can barely hear you.
I'm just suggesting that since this is a public meeting, that we do not sequester any witnesses. I don't see any reason to do that. I do think if Ms. Lemon has witnesses that she needs to release for a while, but can be ready to come back, I mean, that's perfectly permissible.
So in the matter of the petitioner's motion to sequester first for certain witnesses, all in favor say aye. All opposed say no.
No.
No. The motion is denied. And you may proceed now with your opening statement.
Okay. Good morning again, everyone, commissioners, and all those who are present for this hearing. Again, my name is Karina Lemons, and I represent the petitioner employee who was terminated, Mr. Eric Juarez. This case is about an experienced and dedicated public servant who was wrongfully terminated by the city of Raleigh without just cause in violation of its own policies and under circumstances that point to discrimination and retaliation, even though I know we won't be presenting evidence on that. First, Mr. Juarez was dismissed without justification. The evidence will show that he had a great performance record, including a successful performance evaluation for the year 2023. He had no warnings, no write-ups, or no counseling on the record prior to his suspension and termination. He had been with the Department of Housing and Neighborhoods since 2022, and he had received no poor performance evaluations, no write-ups, no counseling. The city's cited reasons for termination, the alleged mishandling of a demolition contract and procurement issues will be shown to be inaccurate and unsupported by evidence or grossly exaggerated. We'll introduce documentary evidence, including emails, the contract, the city policies that contradict the conclusions of the city's internal investigation. You will hear from credible witnesses who will be able to support their involvement in some of the underlying allegations that the city used to justify their termination, and it will contradict some of the, much of what the city has presented. There were other reasons for his termination, and they weren't due to just cause, they weren't due to any type of justification. And you'll see that during, and I don't really see how we can show that without showing the retaliation piece, but certainly we can present, you can discard whatever information that you may hear or see in the documents that point to that. In the end, you're going to see that Mr. Juarez, he did not fail the city failed him, and we respectfully ask that you grant him at least back pay and restore any benefits that he lost, reimburse him for his attorney's fees, and compensate him for any damages allowable under the Raleigh Civil Service Act. Thank you.
Thank you. The city's response?
Good morning again, and may it please the commission. Again, my name is Molly Gross, and I'm here on behalf of the city of Raleigh. You will hear a lot of smoke and mirrors today by Petitioner in an attempt to confuse and distract you from the simplicity of this case. This case is simple, and it all comes down to one email sent by Mr. Juarez on June 21st, 2023. The contractor told Mr. Juarez the permits had not been approved, and Mr. Juarez, knowing that the proper permits had not been obtained, issued the notice to proceed anyway. Realizing he'd made a mistake, Mr. Juarez withheld payment for months to distract from the fact that he was the one who issued the notice to proceed in error. There is no explaining away or distracting from the fact that Mr. Juarez hit send on that one email. At every stage of this adjudication and appeals process, the degree and kind of discipline was made on the basis of sound and considered judgment. Petitioner will not be able to show that the city violated its discipline policies or the city's actions were unjustified. And Petitioner will not be able to explain away the fact that he hit send on that one email. Thank you.
All right. Thank you. Ms. Lemons, you want to present your first witness?
I'd like to present my first witness, the petitioner, Eric Juarez.
All
And
right,
would you like him to sit on the? over
Yeah,
here?
that would be great if you'd sit in the witness seat, and Madam Court Reporter, if you will swear the witness when he's seated.
And if petitioner does not object, we'd like to pass out the stipulated exhibits to the commission at this point so that they can follow along.
Yes, no objection.
Thank you. Mr. Juarez, do you have your ID on you? Yes. Thank you. Thank you so much.
Would you put your left hand on the Bible and raise your right hand, please? Do you solemnly swear today to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you so much.
Please state your full name for the record.
Yes, it's Eric Alexander Juarez.
And what was your most recent position with the city of Raleigh?
It was Planner 1, Senior Construction Coordinator for Housing and Neighborhoods.
And how long did you work with the city?
I've been employed with the city since October of 2013.
And what roles did you hold before working in housing and neighborhoods?
My first role with the city in October of 2013 was with facility operations. as a construction coordinator, and then I was promoted to senior construction coordinator with the Transportation Transit Department, and then the recent position, October of '22, to Housing and Neighborhoods.
Okay. Can you describe your general responsibilities and your most recent position with the Housing and Neighborhoods Department?
The role I held there as a planner was to manage projects for the senior renovations up to 100,000, inspect work during the stages, also inspect work and process payments for third-party vendors, which dealt with senior renovations up to $15,000.
What was your official position, your last official position with the Department of Housing and Neighborhoods?
It was Planner 1 dash Senior Project Coordinator.
And in that position, can you describe any performance reviews and evaluations that you had in that position?
Yes, there was an FY23 performance evaluation that basically covered the period from October 2022 to June of 2023.
Okay. And in that performance evaluation, can you recall essentially the nature of that evaluation?
Basically that I successfully met expectations in my role. My supervisor, Hillary Leacock, mentioned that I came to the department when there was a shortage of staff, and I was able to take on projects and extra roles and didn't mind doing the additional work and supporting the unit.
I'm going to turn your attention to stipulated exhibit number 7 that's in your binder. It's behind tab 7, and on the top it says stipulated exhibit 7.
I'm sorry.
And is this the performance evaluation that you just described in your testimony?
Yes,
And what overall rating did you receive?
successfully meets expectations.
Okay. Was there any mention of performance concerns or issues raised in this evaluation?
No.
There are multiple categories here in your evaluation. And there is contract management, page 5 of 11 is what it says, top right-hand corner. And what was your rating in that section?
Successfully meets expectations.
Okay. And what is the description or goal of that section?
Should I read from it?
Yes, if you
I'm
can
sorry.
let us know what that is.
This position is responsible for the management and coordination of
Madam
work.
Chair, we need to go off record for a moment because we have issues with the
Yes.
computer.
Mr. Waters, if you could just hold on for just a moment.
So sorry. Okay, the last thing I had was Ms. Lemons had asked him if there was any mention. I'm not sure what the mention was, and he said no. Before that was, you were looking in number 7 in the binder. Does that help you where you were, Ms. Lemons?
Yes, I can,
Okay, let me start this up then.
do you have where I asked about the contract management section?
This isn't going to let me record again. I'm need to set this all again. I am so very sorry about this. Technology is nice until it fails. Okay, I have the new thing set up, so I can go back on. And if you wanted to start where you mentioned about, you asked me if we had the content.
Or contract management section?
Okay, I'll go back on then.
Okay.
We're back on the record, and the time is 10:29.
Thank you, Ms. Lemons, if you want to proceed.
Mr. Juarez, what is the goal or description under Section 2.2 contract management?
The position is responsible for the management and coordination of the work performed by consultants to include the rehab specification writer, environmental testing, termite inspectors, engineer, architect, and surveyor. The coordinator is responsible for soliciting these services via a request for proposal and a request for qualifications, and selecting and recommending. Once selected, the coordinator is responsible for all invoices, ensuring that all contracts are current and funded.
Okay. And what was the comment by Hillary Leacock?
Stated above, it says all contracts are current and funded.
And who is Hillary H. Leacock?
Hillary Leacock was my supervisor.
Okay. And under the Section 2.3 regarding payment processing, what were the goals or description for that?
The position is responsible for review, approving, and routing all payments, invoices related to the rehab program.
And what was your rating for that section?
Successfully meets expectations.
And what were the comments that your supervisor provided?
All invoices are reviewed and processed according to program guidelines. Eric is not afraid to challenge contractors if invoices have inconsistencies.
Since it has here your start date was July 1st of 2022 in this position, based on this, it says start date, is that the evaluation period for this?
For FY '23, it would have been July 1st of '23, I'm sorry, of '22.
Okay.
Because we're-
And your start date was actually, for this position, was?
October of 2022.
Okay. So did you receive any counseling or disciplinary actions in regards to either of these sections prior to your termination?
No.
And when was it that you first heard that these areas were of concern, requiring some type of disciplinary action?
It was brought up to me when I met with the HR rep, McCrae, the following Thursday after I was suspended with pay.
And when was that?
I was suspended with pay on February 29th, 2024.
Okay. I'm going to turn your attention to exhibit number 12, stipulated exhibit number 12. Have you seen this document before?
Yes.
And what is this document?
This document is the HR rep McCrae's summary written to MLS Sutton and the HR director.
Okay. And during this process, did Ms. McCrae ask you questions about certain topics?
Yes, she did.
Okay. And when did you meet with her? When did she ask you these questions?
The following Thursday in March, I believe it was Thursday, March 6th, 2023.
Okay.
No, I'm sorry, 2024.
And during that time, were you still employed by the city?
Yes.
Were you still working, or were you on some type of disciplinary action?
No, I was not working. I was walked out of the office on February 29th, 2024.
Prior to being walked out of the office, were you informed of anything that you had done to warrant being walked out of the office?
No.
So from February the 29th until you met with Ms. McCrae, you didn't know what this was about?
All I remember is Sutton handing me the memo, basically stating that I was suspended with pay. I asked Ms. Sutton, there was a witness, another supervisor present, and she said, the HR rep will tell you misconduct in addition to.
Okay. And was the interview for this investigation, was that the first time you spoke with Ms. McCrae?
Yes.
And who is Ms. McCrae?
She is the HR rep that was assigned to housing and neighborhoods.
And what did she inform you that the investigation was about?
She basically said that it was about trying to post a request for proposal less than 72 hours, the Susan incident, and the failure to pay Corbett Construction within 30 days.
Prior to this investigation, had you made any formal complaints to HR?
No.
Had you contested any actions of your supervisor prior to this?
No.
I'm going to turn your attention over to Exhibit 1, stipulated Exhibit 1. And if you can review through this exhibit and just let us know what this is.
Under Section 1, it talks about performance training and development. So it was an annual, mid-year and annual for the first department I used to work in facilities, were Crystal Littlefield.
I believe you're looking at the city's exhibit number
Oh,
one.
I'm sorry.
So stipulated exhibit number one will be behind the city or employee exhibit. So it should say stipulated exhibit number one. It should have the name Connie Bragg on it. There's labels on the tabs there to identify.
1/7/6/2023. Yes, okay.
All right. So if you can look through this stipulated exhibit 1, and it says stipulated exhibit 1 on the top, page 1 of 13, if you can identify what this is.
It's a email from David Gray in July 6th of 2023, stating that the EI invoices were in accounts payables as not paid, and they had to be paid.
Okay. And do you recall anything about this situation?
Yes, at the time, Tierra O'Neill was working as a senior fiscal specialist in the municipal buildings finance department. Typically, an invoice is submitted to the finance department at the R&B, and then it waits for the department to submit it in order to match it. In this particular incident, Ms. O'Neill is telling David, we have 2 invoices from the EI group that haven't been matched.
And why had, to your understanding, why had the invoices not been matched?
In order to match an invoice, the department has to acknowledge the invoice, confirm the accounting number, and then process it and send it to R&B's finance department.
Okay. And with this particular invoice, who was that invoice sent to?
So the EI group sent the invoice directly to the R&B finance department.
And where should they have sent it to?
The boilerplate documents and state that the vendor or contractor is to send all invoices to R&B finance department. And then internally, we also tell the vendor or contractor to send it to us as well.
No, when you say boilerplate documents, which boilerplate documents are you referring to?
The standard standard construction contract or services contract that is written by the city attorney's office.
Okay. So in the contract, it says that they're supposed to send the invoices to the finance department?
Yes.
Okay. And that's what they did in this situation?
Correct.
And when they sent it to the finance department, what was David's response?
Basically, after Tierra O'Neill sends the email to David saying you have 2 invoices that haven't been matched, David sends it to our unit, copying Hillary Leacock's boss, stating that the 2 invoices have not been submitted for payment, and the last day to submit is tomorrow, July 7th.
Okay. Looking at the next set of emails there, behind that?
Basically, I responded back to David stating, well, the attached invoices are dated June 1st. Are you sure they can be processed since they're over 30 days?
Okay. And what was his response?
His response was, unfortunately, we don't have a choice. EI has already submitted them to accounts payable, which I have said many times for everyone to reach out to their vendors and tell them not to send invoices to accounts payable, only to send them directly to us, but some vendors do it anyway. Since accounts payable already has them, we must submit them, and they must be submitted before 3 p.m. tomorrow, which is the last day for any invoices for FY 22-23.
And did you receive, it looks like the vendor sent it, you weren't involved in that?
I was not, no.
You weren't involved in that, and you didn't receive any disciplinary action or counseling on this issue?
I did not. I did not receive any disciplinary.
The next page of this exhibit, page 3 of 13, its subject line is Families Together, 1100 Athens Drive. And do you recall this? It's got an email and it's got some invoices attached to it. And do you recall dealing with this vendor?
Yes, Families Together, yes.
Okay. And could you tell me about this invoice from Families Together?
Yes, Families Together submitted the invoice to me, I believe, a few days before the director signed it. Their director for Families Together signed it on June 3rd, 2023.
Okay. And when they sent it to you, were you able to accept the invoice?
When they first sent me the invoice, I did not accept it. I sent the reply back, including the director, to inform them that I needed their signature in order to process.
Okay. And on page, looks like 6 of 13, is that confirmation that you received their signature?
The cover page for the invoice, yes.
Yes. And what day did you actually receive the signature from them?
It looks like October 3rd, 2023.
Okay, so they initially sent it to you on September 27th, but then they got it back to you signed on October 3rd. And when are the payment of these invoices due?
For this particular vendor,
Yeah, are there different deadlines depending on the vendors?
depending on the vendor or nonprofit, once the invoice is submitted, if it's not a construction invoice, construction invoices are only paid out net 30 from the day of the invoice. All other invoices can be paid sooner.
This particular vendor, are they a construction vendor?
No, they're a nonprofit.
Okay. And when you received the invoice on October the 3rd, who did you speak with about the invoice or communicate with?
No one.
Okay. What did you do when you received the invoice?
I processed it later on.
What does that mean?
I'm sorry.
The commission doesn't work.
I'm sorry.
Commissioners don't work in Housing and Neighborhood Department. So when you say you process that, what does that mean?
Typically, when you receive an invoice, you have to have a cover sheet form in which you type in the account number, and it has the signatures of the individuals in the department. They have to review it and date it. And there's also a spreadsheet you reference in the attached documents, which shows the account number, the opening balance after you process this invoice, and what is remaining on the invoice, funds.
So in part of processing it, are there layers of approval that needs to happen in regards to that? Explain the levels of approval.
Yes. So I fill out the forms, the 2 forms, the cover sheet for the invoice, attach the spreadsheet, and attach the invoice. I then send it to my supervisor, Hillary Leacock. He reviews it, and then he would send it to Erica Brandt, his supervisor.
After it's sent to Erica, then who gets it next?
After Erica reviews and signs it, it's sent to David Gray for processing.
Okay. And for this particular invoice, to your knowledge, was this able to be processed within 30 days? Or paid within 30 days?
I don't have access to the financial software to see if it was paid.
On page 8 of 13,
This is the invoice routing form that we fill out.
okay. And the invoice routing form, does that mean that you're sending the payment?
The invoice routing form is me acknowledging the invoice, collecting the information, data from that spreadsheet, remaining balance, and sending it to my supervisor to review and send forward.
Okay. And again, this particular payment wasn't required to be paid in 30 days.
No, only construction invoices are to be paid net 30.
Did you receive any complaints or concerns from families together that they had not been paid?
I did not.
Okay. On the next page, page 8 of 13, and that's in regards to 2805 Glasgow escrow balance sheet. And if you can please explain, if you recall, what this is in regards to.
Yes, 2805 Go was a renovation project up to $100,000 for seniors in the city.
Okay. And was that project, was that one of your projects that you were working on?
Yes,
And was that invoice paid?
yes.
Did you receive any counseling or any feedback on, from your supervisors regarding payment of this invoice?
No.
I'm going to turn your attention to stipulated exhibit number 19. You're going to have to turn some pages here. If you could take some time to look at the document and let me know what this is.
It's a email conversation between Emily Sutton and myself, including Hillary Leacock, and the then assistant department director, Lamont Taylor, regarding 408 Bolin Court.
Okay. And was there an issue regarding the invoice for 408 Bolin Court?
Yes, this third-party vendor, Rebuilding Together of the Triangle, Mr. Dan Sargent, had submitted an invoice, and my role was to investigate, to confirm the work had been performed, take pictures, document, review invoice.
Okay. And when you reviewed the invoice, did you have some questions or concerns about the invoice?
I did. I communicated with Mr. Dan Sargent that I had questions regarding a fan attic or an exhaust fan and the washer-dryer line items, if they were purchased by the homeowner and installed by families together of the Triangle.
And what was Mr. Sargent's response to, I believe if you could turn to page 3 of 3, where it says on Monday, Jan 29, 2024, at 12:33, says Eric Juarez wrote, "Hello, Dan, is this the questions that you had for him?"
Yes, this is the email I sent to Dan Sargent regarding my questions.
And what was his response?
Mr. Sargent's response, should I read from it?
If you, we have it there before us. If you can kind of explain what his response was in general to your statement.
He stated that
Objection, the document speaks for itself.
What's the question again?
I asked him for the response. He asked me if I wanted him to read from the whole thing. And I said, in general, what was the nature of his response?
Mr. Sargent is telling me that this program is designed differently, and as well as my role is different as well. Rebuilding Together of the Triangle is a general contractor in the rehab of these homes. Rebuilding Together the Triangle supplies the materials and cost, and there's a fee structure to be paid to Rebuilding Together the Triangle.
And was his statements to you about the nature of the project correct?
It was not, because prior to Rebuilding Together the Triangle, they had a third-party vendor resource for seniors, where I would also go out, inspect the work that was finished, take pictures, review their invoices before they were paid.
Okay. And the date of this email was? Sorry.
The communication, it was February 6, 2024.
And it looks like he CC'd Emila Sutton. Who is Emila Sutton at that time?
Emila Sutton is the Director of Housing and Neighborhoods.
And did she respond to that email?
Yes, she did, on February 6.
Okay. And what was her response?
Her response read as, I think Dan will reply to your appliance questions, and it's good for us to know. We would reimburse either way, since the work is done. But it would be good to understand why those included, since it's a bit unusual for a rehab.
At that point, how long had Ms. Sutton been with the Department of Housing and Neighborhoods?
Ms. Sutton began in October of 2023.
So this is 4 months into her role?
Yes.
And were you informing Mr. Sargent of the actual policies concerning this program?
Yes.
And you responded to Ms. Sutton's email there at the top, looks like partially in the bottom of page 1 and the top of page 2 of 3?
I did, and I stated to Ms. Sutton that after reading Dan Sargent's email, it felt that he was coming off defensive, and or if he was instructed by someone else to tell me what I needed. And reminding Ms. Sutton that we, the city, are paying the contractor Rebuilding Together the Triangle for services, and transparency is a must. The other item I noticed in this particular home was the spending of testing for asbestos and lead at a cost of $600, where the home was constructed in the early 80s, which is past the asbestos lead period.
And you indicated there, that last sentence.
The other contractor, Resource for Seniors, never had any issues with my questions.
So it's not uncommon for you to ask questions regarding invoices to contractors?
No.
In response to that, what did Ms. Sutton say in response to your email?
Ms. Sutton responded, per my prior email, see below with some additional comments. I will not repeat myself on this topic, Eric. While I appreciate your thoroughness and concerns for protecting the city's interests, you need to better understand your role and think about how you communicate with Rebuilding Together of the Triangle, as well with me. Per my prior email, there is no reason why we or you need to see prices for an inspection. Your COR, City of Raleigh's role is to sign off that yes, the work described in the scope was done, and no, it was not.
I'm going to stop you right there and ask a follow-up question. Why was it that you were asking questions about the items listed on page 1 of 3, particularly the washer, dryer, cooking range, and asbestos testing?
When I reviewed the invoice for that particular project, the washer dryer stood out to me, and the attic fan stood out to me, since I didn't see any change orders in the original scope.
And was there a policy or something that, why did it stand out to you?
In other projects that I also worked with, which was the up to $100,000 rehabs for seniors, an appliance package is provided to the contractor who wins the bid. The appliance package consists of a refrigerator, a stove, and a dishwasher.
And so these were washer and dryers. That's not included?
And it is not.
Okay. And were you responsible for writing up the RFP for this?
No, the RFP for these services to the third-party contractor was not written by me. It was,
Did you review the bid of the contractor?
I did not.
What raised the red flag? Did you go to the bid and look at that?
I referenced in 2 prior meetings that the unit had with the finance department within our housing. I raised the question, and in the meeting, we discussed the written item that Erica Brandon had written in reference to what is covered. And the question came up as Erica wrote energy efficient appliances. It wasn't detailed whether it was an allowance, refrigerator, dishwasher, or stove, or washer dryer.
Did you have any concerns regarding any type of funding, federal funding or grant restrictions in regards to the washer and dryer for this property?
I did, because I was referencing the up to $100,000 project, the appliances, allowances. We had never installed a washer dryer or purchased a washer dryer, and was afraid that the feds, when they audit, would be a red flag.
Ms. Lemon, can we take a brief break? We've been going at it about an hour and a half. Let's take about 8 minutes.
Okay.
And off the record.
I was asking you about stipulated exhibit number 19, and I had asked you about Ms. Sutton's response to your concerns about the 408 Boylan Court invoice with Families Together. Did Ms. Sutton counsel you or write you up or have a conversation with you after this email?
No.
I'm going to turn your attention to stipulated exhibit number 5. My apologies, number 12. I have the numbers changed. And we had already taken a look at this earlier, but I'm going to direct your attention to page 405. There were some investigation findings that Ms. McCrae made there on page 405. And I want to ask you about some of the findings that she made, or the facts surrounding that. So the first one is that Eric Juarez and Blank knew that Corbett Construction lacked the required permits to demolish the property on New Bern Avenue, and that you issued a notice to proceed for the property on June 21st of 2023. Okay. So the question that I have about that is, did you talk with Corbett Construction regarding that property and the demolition of that property?
Yes, I did.
And what was your conversation with Corbett?
The conversation email was with Kyle, who is the estimator for Corbett Construction.
And what was the scope of that project?
The scope was to demo 3 duplex units located at, I forgot the name of the village that we named the village, Duplex. Yeah, Duplex Village.
And were there some stipulations to that project in terms of the timing and the pacing of the demolitions?
Yes, there were stipulations outlined in the request for proposal and the addendum 1.
Okay.
As that the contractor had to submit a demo permit for each of the units to be demoed. Each unit had to be demoed one at a time and stay within the 12,000 square feet plot plan.
Okay. I'm going to direct your attention to Exhibit 8, that big, thick 162-page document. And is this what is this document here, stipulated Exhibit 8?
This is the contract for construction and repair services that was written between the City of Raleigh Housing and Neighborhoods and Corbett Construction.
And under the description of work there, it discussed those buildings that are the properties that are going to be demolished, is that right, correct?
Yes.
And I think there, you had mentioned that they have to obtain necessary permits.
Correct.
And do you see that there in the contract?
Yes, where it says contractor shall complete demo of structures. Contractor shall obtain all necessary permits. It is the responsibility of the contractor to provide notice to all adjacent neighbors.
Okay. In addition to that, on the next page, it looks like the scope of work continues.
Yes, I wrote specifications outline and request for bid 274, which is Housing and Neighborhoods Unit, Department Unit, 02/01/2023, the day that the bid was posted.
In addition to that, what else did it say was included in the scope of work?
It also referenced the Addendum 1. Addendum 1 consists of questions that would have been asked during the pre-bid meeting where contractors attended, and after the pre-bid meeting was held, there would be additional questions submitted by the contractors.
And what is the additional part of the scope of work there? The last item there.
Bid submitted by Corbett Clearing and Demolition dated February 24, 2023.
Okay. And so the first, looks like on the bottom, there's a 10, or there's a something of 14 on each of the bottom of the page numbers. Is that the actual contract itself?
Page 14, you said?
No, that on the bottom left-hand corner, you'll see a number of 14.
Yes. The boilerplate contract is made up of 14 pages.
Okay. And in addition to those 14 pages, are all the items that you mentioned in the bullet points a part of that contract?
Yes, the request for proposal and the addendum.
And if you look at page 15 of 162 on the top right-hand corner,
Yes.
and what is that document?
This is the bid submitted by Kyle Corbett, the owner of Corbett Construction.
And in his bid, how many of the following pages, or where does his end, his bid, his actual bid? And make reference to the top right-hand corner page numbers.
Bless you. His bid consists from page 15 to page 39.
And all of this is a part of the contract?
Yes.
Okay. On page 19 of 162, what is that? Can you explain what that is?
Page 19 is Addendum 1, which is the list of questions the contractors would have had at the pre-bid and the period after the pre-bid before the bid was due.
Okay. And did they agree that they were going to abide by the terms under these questions?
Yes, I always ask a bidder to submit any addendums that were outlined and for them to sign and acknowledge and turn in with their bid, which is on page 20.
Okay. After page 39, you said that it ended on 39, that ends their bid. What is the next set of pages?
Page 40 is the copy of the request for proposal that I wrote and was posted on North Carolina IPS website.
Okay. And the request for proposal, can you explain what that is?
A request for proposal basically outlines the department's need or widget services to be completed. It specifies details of the project, actions to be taken by the contractor, and also includes, in this particular case, asbestos testing of any sort that was done by the EI group.
Okay. And where does that section of it end, the request for proposal?
Page 162.
Okay. In dealing with Corbett Construction on this project that's located in this contract under stipulated Exhibit 8, did you have any issues regarding the project?
From Corbett's,
Yes, were there any issues regarding the project with Corbett, with the contractor?
yes.
What issues did you have with Corbett Construction?
Kyle, who was the project estimator from Corbett, submitted a permit for the first project, or first duplex unit. He emails me and tells me he submitted the permit, a few of the departments have signed off, and there was a question about erosion fencing to be added since it wasn't outlined in the plot plan for each of the duplex units.
Okay. And what was did you answer his question regarding that?
Yes. I responded back that I had been out of the office and to provide me with the construction schedule and when are you looking to begin.
Now, in regards to these buildings, was there could all of the buildings be demolished at one time, or was there some type of requirement regarding how many buildings could be demolished?
As outlined in the request for proposal, it was specified that each duplex unit had to have its own demo permit opened and closed and inspected and stay within the 12,000 square feet plot plan square footage.
And did the contractor do that?
No, he ended up demoing 2 out of 3 units.
And were you aware that he was going to demo those first 2 prior to doing so?
No, I was not.
What happened when you found out that they had demolished those first 2 buildings?
After he had demolished it, it triggered the greater than 12,000 square feet, which the city considers that as a mass grading plan.
And what does that mean in layman's terms?
A mass grading plan means that your project, which is 1 unit, a duplex unit, now has become a larger scale project where multiple additional reviews are needed.
Okay. And what was your response to the contractor for doing that?
I informed Hillary about the plot plan requirements from Development Services. He told me that he had worked with the civil engineer prior to me starting and had submitted a plot plan to the state and was approved.
Okay. And then what happened next in regards to the third property, the third building that was to be demolished?
I believe that was demolished after as well.
Okay. Did you issue a notice to proceed on that third building to the Corbett
I did not.
contractor?
I did not.
Okay. And did they obtain the required permits?
At the end of the day, in the summer of 2023, there was only 1 permit listed that was open and closed in Development Services website.
Okay. I'm going to direct your attention to stipulated exhibits 5 and 6. In Exhibit 5, can you describe what that document is?
Yes, page 1 of 3 is a demolition permit for one of the duplex units at 1940 New Bern Avenue.
Okay. And on Exhibit 6, can you describe what that is?
Exhibit 6 is a demolition permit for the other duplex unit listed as 1925 Hawking Street.
Okay. And what's the date of that permit issue?
It is June 6 of 2023.
And did you give us the date of the permit on Exhibit 5?
It was July 6, 2024.
Okay. sorry. Oh, I'm sorry. Oh, can you, so in terms of Exhibit 5, that was the address for that demolition permit?
Yes.
What were the permit details on that?
Set 1 included 1940 New Bern Avenue duplex, and it was a demolition permit issued to General Contractor DC Allen Company.
Okay. And is there anything in particular on that permit that is unusual or out of the norm?
No, it's a standard demolition permit that basically outlines the details of the property of the site.
Okay. And what's the company that issued the permit on Exhibit 5?
The permit was issued to DC Allen and Company, who was the winning bidder for Set 2 of the demolition of Duplex Village.
Okay. And were these the buildings that Corbett had demolished?
Correct.
Okay, so Corbett demolished the buildings and DC Allen obtained the permits after the fact? Okay. And in Exhibit 6, Corbett, did they demolish those buildings?
Yes,
And they received the permit? They
correct.
obtained
It
the
was
permit.
issued to Corbett.
Okay. And why is it that DC Allen were the ones that issued the permit rather than Corbett if they didn't do the work?
I wouldn't know how to answer the question. I was not in the department.
Okay. July 16th of 2024. What was your termination date?
Termination date was May 22nd or 25th of 2024.
Okay. I'm going to direct your attention
No, it was there.
to the correspondence regarding that project, an exhibit, and this is going to be all the way in the back. It's stipulated Exhibit 28. 28. Now, did the contractor, did Corbett have concerns about not being paid for demolishing those buildings?
The owner did, yes.
And what was their concerns?
Their concern was that they did the work and they wanted to get paid.
Okay. And did they get paid?
Yes, they ended up getting more than half paid in September of 2023.
On that page 3 of 3 of that exhibit, that last page there, there are separate invoices for the work. Explain why there are multiple invoices for the properties.
The invoice is described as each of the duplex units, and it also references the pricing that the bidder, Corbett, submitted with his bid.
And is there a payment indicated on here?
Yes, at the bottom of the invoice, there's a negative 9,800. It has a reference number and an invoice reference number, which is generated from PeopleSoft, the City of Raleigh software.
In addition to this payment, did they receive additional payments for the work?
Yes.
Okay. And I'd like to direct your attention to Employee Exhibit 1. And that would be in the back. Do you guys have an Employee Exhibit 1? No? Oh, okay. I thought you guys were making copies of the exhibits. That's okay. I can. I'll ask him about these and then we can pass it around. I thought when they were doing the notebooks that the copies would be included, so my apologies.
Can we get copies made?
Wherever it is.
I guess an alternative, I'm sure you can't use this without, unless it's already in the system. So
Oh,
yeah,
this
let's
is
just
the
have
same
copies.
thing. That's the witness
And
copy.
if there are other copies that we need to do at the same time.
That's the only exhibit that wasn't stipulated to.
Right away.
We'll be on a brief break to get that exhibit copied.
Need a copy?
We would like a copy too. Thank you. Thank you.
We can go back on the record.
Okay. You have in front of you Employees Exhibit Number 1. And if you could indicate what that document is.
Yes, employee exhibit number 1 is a copy of Corbett's invoices.
Okay? And how many invoices do you have there that they submitted?
3.
And does that represent all the invoices they submitted?
Yes.
Why did they submit 3 separate invoices instead of 1?
3 invoices were to be submitted as outlined in the bidder's bid for each of the duplex unit. In this particular 3 invoices, we, Hillary and I, agreed to pay the contractor 70%.
And this first invoice in the front here, it says,
Oh, the first invoice is referencing 1925, 1927 Hawking Street.
okay. And what was the amount for that demolition?
$9,800.
And did the city, to your knowledge, pay for that?
Yes, they did.
And what are the notes located on the bottom there in blue?
The notes that I wrote were the receipt number, which would have been generated with with PeopleSoft, the city's finance, the day the invoice was entered, and the day a paper check was cut.
On that invoice, it has 2 dates, an invoice date and a due date. What was the invoice date?
Oh, I'm sorry. Invoice date is September 8th, 2023. The due date was September 29th, 2023.
And what was the date that they were paid?
A paper check was cut on September 21st, 2023.
And that was before it was due?
Correct.
On the next page, there is an additional invoice. And it looks like it says Duplex Village Step 1, Demolition Services, 1925-27 Hawkins Street. So it looks like it's for that same set of properties with a different invoice number.
Correct.
Okay. And what can you explain about this particular invoice?
This invoice is outlining line item 1 for $9,800 for Russ Street, which is another duplex building, and line item number 2, which is Hawking, Russ, and New Bern.
And it looks like there was a payment applied that was made.
Yes, $9,800 payment is referenced, and a reference number and invoice reference is detailed.
And that left a remaining for job invoice number 2?
Yes, minus 10%.
What was the date of this invoice?
The date of the invoice is October 26, 2023.
And what was the date that it was entered?
It was entered on October 31st, 2023,
And when was the invoice paid?
November 2nd, 2023.
And then on the third invoice, it looks like that one's dated November the 15th of 2023.
Correct.
And what is this invoice in reference to?
This invoice is the remaining 10% of the total project.
So at this point, it looks like $26,995 had been paid
Correct.
out of $29,950 that was owed.
Correct.
And this last invoice for $2,995, when was that entered?
It was entered on December 21st, 2023.
And when was it paid?
December 21st, 2023.
Now, this payment is later than the previous 2 payments. Do you recall why this payment was later?
I remember that in order to receive a paper check, there's special requests that David Gray has to submit to the finance department at R&B. And in this particular instance, we were just going to do an ACH or direct deposit to it. And I think he still wanted a paper check.
And did that cause a delay in him receiving his payment?
Yes, because it's, again, David Gray has to do a special request to finance at R&B.
Okay. Now, did you receive any feedback or concerns from your supervisors about the Corbett situation?
I did not.
Is David Gray, is he in your chain of command?
No, he is not my supervisor.
Okay. And what is his relationship to you, or was his relationship to you while you were at the Department of Housing and Neighborhoods?
David Gray had dealt with the financing, accounting numbers, and ensuring that the funds were available in order to pay an invoice.
Okay. There was one other thing I wanted to ask you about. And that is exhibit, if I turn your attention to exhibit 15. And what is the date of this document stipulated exhibit 15?
It's January 27th, 2023.
Okay. And what is this document?
It's an email notification from David to me, my boss, Hillary Leacock, and my coworker, Tammy Nelson, Donado.
Okay. And what was the subject matter of this email?
He is informing me that Shakita, who is a purchasing agent in the R&B purchasing unit, is not able to post and request for proposal in less than 72 hours.
And it looks like you all had an exchange back and forth about that.
Yes, because I originally sent it, the request for proposal, attachments and outline of dates, to his employee, Jamie Marks. And then I explained to David that Shakita had given me the green light to go ahead and post this for set 1, since it was a duplicate copy of a prior demo project at 2000 Hawkins Street.
Okay. And was there an issue with, and could you speak up into the microphone? Was there a concern about publishing the RFP for the date that you requested?
Yes. Basically, David said, if you can just change the dates, we'll be able to post it, and it would not be posted on the following day.
Okay. And it looks like there's no response for you listed here in this email thread. Do you recall what your response was to David about changing the dates that it could, when she says, Shakita is the one who said it couldn't be published today? What was your response to him?
I responded back and included Jamie with the updated dates to post the RFP.
And so essentially you complied with the request to change the dates for the RFP.
Correct.
Were you disciplined or counseled in regards to this incident?
I was not by my supervisor, no.
You had a performance evaluation that we looked at later in the year.
With an end date of June 30th,
Of June
2023.
That was exhibit, go back to exhibit 7 there. And under 2.2 contract management that deals with the RFPs, What was your rating in regards to managing RFPs?
Successfully meets expectations.
And did this evaluation period cover the date of that email that we looked at? in
Yes, it
Exhibit
did.
15? Okay. All right. Was there anything else that you would like for the commission to know about your termination being unjustified?
Yes. It just felt that since I had brought up 408 Boland Court to Emila, had questioned their third-party contractor, Rebuilding Together of the Triangles, that suddenly 2-3 weeks later, both my supervisor and I are suspended with pay and walked off the floor if we were criminals.
When you say like you were criminals, what do you mean by that?
I just pictured something where just grab whatever's on your desk, leave your computer and your cell phone, and we will escort you. Meaning that as if the police had come and removed you from the floor.
When did Emila become the director of housing and neighborhoods?
October of 2023.
So that was just a few months before this incident that you were suspended, walked out.
Yes.
Had Emila counseled you other than that, families together, I believe?
Rebuilding Together.
I'm sorry,
Dan
rebuilding
Sargent.
together. Other than that, the washer and dryer incident, had she ever questioned your work?
No.
Had she ever counseled you about your work?
No.
I don't have any further questions at this time.
Thank you, Your Honor. We do have a few questions. Good morning, Mr. Juarez. I just have a few questions for you, if I can get this microphone positioned properly.
Good luck.
Okay. Please turn to stipulated Exhibit 23 and take a look at page 2. So according to Kyle Radford from Corbett Demolition, on June 20th, 2023, he sent you an email. It's short, so I'll just read it to you, and you let me know if I misread it. Eric, we had submitted the permit over a week ago, and it has been approved by a few departments, but not all. And I apologize, the subject is 1940-1942 New Bern Avenue. Tree protection verbiage wasn't included on the plot map for the duplex on New Bern Avenue, but we have added it and resubmitted it. Are you okay with us beginning demolition tomorrow on New Bern so that we don't have to remobilize? Please let me know as soon as you can. Okay, if you go to page 1, you responded on June 21st, 2023, sorry, Eric, it's been a busy day. Thanks for getting back to me. Oh, I'm sorry, I'm reading the wrong page. It says on page 2, hello, Kyle. I have been out of the office since last Thursday. Left you a voicemail earlier today on your cell. Yes, you can move forward. Demolition schedule. When are you thinking of starting? And again, you're responding to an email with the subject line RE 1940-1942 New Bern Avenue. Did I read that exchange correctly?
Yes.
Okay. So it's reasonable then for Mr. Radford to have proceeded with the demolition of the property on New Bern Avenue, according to this exchange, correct?
The email exchange, correct, but Corbett Construction was familiar with the city's pre-demo, pre-construction meeting since he did a lot of work for the city's public utilities.
But Mr. Juarez, did you not tell him it was okay for him to proceed with the demolition project even though he didn't have the permits?
Yes, and I'm asking for a demo schedule.
You said, yes, you can move forward, demolition schedule. When are you thinking of starting? So by that, you're saying you didn't issue a notice to proceed?
A notice to proceed is a boilerplate document that the department issues to a bidder or contractor, which outlines the day that you had your pre-demo, pre-construction meeting.
Okay, and not to belabor the point, but he's asking you, can we proceed? And you're saying yes.
I said, yes, work schedule, demo schedule, when can you begin?
Okay, so he responds on page 1, sorry, Eric, it's been a busy day. Thanks for getting back to me. We will move to New Bern Avenue either today or tomorrow. And your response is, okay, thanks for update. I'll stop by the job site for photos on Thursday then. So again, is it reasonable for Mr. Radford to have understood that you were telling him, yeah, go ahead, do the demolition?
Yes, it could be read as that.
Well, and it was read as that, correct? Because he did in fact proceed with the demolition.
Yes.
And I understand what you're saying about how they should have known better, essentially, correct?
Mm-hmm.
However, if we can turn to stipulated exhibit number 8, which is the contract between the city and Corbett, and turn to page 2. Okay, you ready?
Yes.
Okay, so right under the bolded part with the bullet points, it says, the contractor shall further perform in accordance with the directions not inconsistent therewith, given from time to time during the construction by the project engineer or of such other official, employee, or other agent of the city as the city may designate. And you were the project manager for this particular contract, correct?
Correct.
So if you give instructions pursuant to this contract, even if it may contradict the description of the work, it is reasonable for the contractor to follow your directions, correct?
Correct.
If we can turn to stipulated exhibit 24, pages 4 and 5, I've got a couple of questions about that email exchange. Okay, so if we look at the email at the bottom of the page, according to again, Mr. Radford, going on to page 5, he asked for your assistance in obtaining a permit for the Russ duplex. And is that the third, if you look at page 5? We went ahead and submitted the permit.
Could I just interrupt for 1 second? What exhibit was that, real quick?
Exhibit 24.
Thank you.
And if we look at page 5, Mr. Radford is asking for assistance for the permit on Russ Street, correct?
Yes.
Okay. And he's saying it specifically because New Bern had been complete, correct? He does say that? New Bern has been complete?
At this point in time, it did.
Okay,
I'm
and that
reading
was-
the email now. Okay.
Okay, and that was on June 27th, 2023. So that was 6 days after you said he could start the demo project on Newbern, correct?
Okay.
And then if we look at page 4, he was asking for assistance, and you responded that you would find out who you could call in the permit office to correct the issue with the rust permit, correct?
Correct.
Okay. And then if we look on pages, starting on page 3, going to page 4, on June 28th, the following day, Mr. Radford once again emailed you to check in for an update on the permit issues for Russ and Newbern, correct?
Correct.
Okay. And then you responded that someone had started the demo on Russ, correct?
Correct.
And here again, you had acknowledged for the units you have already demoed, which would be Hawkins and Newbern, those are the 2 permits you waiting to be issued correctly. Did I read that correctly?
Yes.
Okay, so you're acknowledging that he had already demoed the Hawkins and Newbern properties, right?
Correct.
And there's nothing in this response that would indicate to him that he should not have started those demos. Is that right?
Correct.
Okay. Instead, you acknowledged that there was work on Russ. If we go to page 2, you brought up a separate issue, that there was some work on Russ and asked that the sanitation sewer lines be capped, correct?
Correct.
Okay. So you knew that there was work going on these properties, and according to what we've seen so far, nowhere in these exchanges did you say, you need to stop right now, you don't have permits, did you?
In these email communications, I do discuss a mass grading plan since he exceeded the 12,000 square feet.
But you did not tell him that he had been conducting the demolition in violation.
I did not.
Okay. Okay. And if we can look at page 1 of stipulated exhibit 24, that conversation that you were having continues through July 7, 2023, and at no point through at least July 7th did you bring up that there was an issue because they had demolished the properties in violation of the contract, correct?
Correct.
Let's turn to stipulated exhibit 27, page 2. Okay, and if we look at pages 1 and 2, it looks like Corbett sent you an invoice for Duplex Village, Set 1 Demolition Services, 1925/1927 Hawking Street, 112/114 Russ Street, 1940/1942 Newbern Avenue, correct?
Yes, that is the subject matter.
Okay. And it looks like the project administrator of Corbett Group, Andrea Herring, says, "Good morning. Attached is the invoice for demolition services rendered. Please respond so that we know you received this email." Correct?
Yes.
Okay. And from this string, at least, it looks like you did respond on September 15th, 2023. Is that right?
Yes.
Okay. So between July 17th, 2023 and September 15th, 2023, the city had still not paid Corbett for any of the demolition projects, correct?
Correct.
And that would include Hawkins, to which there's no dispute that they had the permits to conduct that demolition, correct?
Objection. What's the objection? The objection, that's not what was stated. We actually, the documents speak for themselves in terms of the payments for those, the payments that we have in Employees Exhibit Number 1.
Okay, well, let's take a look at Employee Exhibit 1, because the first page says Hawkins was entered on September 21st, 2023, correct?
The subject of the invoice outlines Duplex Village Set 1 and has the addresses of each of the duplex units.
But if you look at the bottom half of the page, it's specifically saying Duplex Village Set 1 Demolition Services, 1925/1927 Hawkins Street.
Correct.
And it says 9,800, and it says total 9,800, correct?
Correct.
And then I'm assuming this is your own handwriting, that the receipt of the payment was entered on 9/21/23, and that it was paid by paper check on 9/21/23, correct?
Correct.
Okay.
Correct.
So as of September 15th, 2023, the city had not issued payment to Corbett for the Hawkins project, correct?
Correct.
And the Hawkins project is not in dispute, correct?
They did the demo, yes.
And they did the demo pursuant to the original contract, correct?
Correct, with the exception of the 12,000 square feet in the permit process.
But Hawkins, they did have a permit for Hawkins, correct? Before they started the demolition.
I would have the reference in this
Okay.
binder.
Let's look at, I believe it's stipulated Exhibit 5. It's actually stipulated Exhibit 6. Page 1. And so they got the permit on June 6, 2023, correct?
Correct.
So there's no issue about whether they got the demolition permits for Hawkins.
Correct.
And the city was invoiced originally on July 17, 2023, but Corbett did not get paid until September 21, 2023. Is that right?
Corbett Construction invoiced us on July 17th for the lump sum of $29,950.
And that included the Hawkins Street,
That included all 3 duplex units.
but that included Hawkins as well.
Correct.
Okay. And so for the Hawkins job, according to your own exhibit, they were not paid until September 21st, 2023.
Correct.
And they should have been paid within 30 days of July 17, 2023 for Hawkins.
A permit is not just issued one day to the next and it's inspected the next day and closed out the following day. In the real world, inspection services has multiple sites to visit. Inspection has to be coordinated and scheduled. If the individual was issued a permit on June 6, it would be impossible for an inspector to come out there and inspect on June 7th.
That's not what I'm asking. I'm asking you, the invoice was sent to the city July 17th,
For the lump sum of the total contract.
and they were not paid for the Hawkins until September 21st, 2023.
Yes, but there were email communications with Kyle, the owner, and his wife, Kelly, Andrea, and Kyle, the estimator, asking for pick tickets where they would have taken the demolition to ensure that the city, that they did not just dump a construction material that had already been abated to a vacant parcel in Johnston County or Goldsboro, where they were from.
But you have not provided any of that communication for today's hearing, correct? So that would just be your own testimony.
There is communication emails.
Okay, well, let's go through those communication emails from July 17 through when when Corbett was finally paid, okay? So let's go to stipulated exhibit 26. Page 5. So it looks like, are you ready?
Yes.
Looks like on July 28, 2023, again, Ms. Herring is asking for a follow-up to see if there's an update on the permits, as well as the payment for the duplex. So she's asking for payment, correct? An update on the payment,
Correct.
okay? Then if we go to page 4, Ms. Herring sent an email on August 7, 2023. There's some discussion about venting pipes being installed. And then she says, can you go ahead and get the invoice processed for payment?
Correct.
Okay. And then on page 3, again, on August 10, 2023, she's asking again, please let me know what additional information is needed to process the invoice.
Correct.
And then on page 2, on August 16th, going from page 2 to page 3, she's asking about payment again, the status of the payment, correct?
Yes, and I responded on August 17th.
I understand that. And you responded that you wanted her to provide 75% of total invoice because you're trying to resolve the mass grading plan.
Correct.
Okay. Then on pages 1 and 2, it looks like your supervisor brought up an issue about payment at that point. And not releasing payment until cleared by inspections, correct?
Correct.
Okay. But up to that point, it doesn't look like there's any communication by you or anyone else from the city in these exchanges that are explaining to Corbett that they are not going to get paid unless certain conditions are met, correct?
Not from these emails.
Okay. Let's turn to stipulated exhibit 28. And I believe we've already reviewed this, but even if we haven't, it looks like on September 25th, again, Corbett is sending an invoice, and the invoice is seen on the last page, correct?
Yes.
Okay, and so by that point, the only payment that had been made is the $9,800 for the Hawking Street project, correct?
Correct.
And nothing had been paid on the Newbern project at that point, correct?
Correct.
And the Newbern project is the project that you and Mr. Radford had communicated about proceeding even though the permits were not complete, correct?
Correct. Which is one of the duplex units, yes.
Okay, let's go to stipulated exhibit to page 2. And in the middle of page 2, there's the email from Mr. Kyle Corbett to Mr. Radford, and he's copying you, Mr. Leacock, Darius Todd, and Tammy Nelson Donado, correct?
Correct.
Okay. And some of this I won't read into the record, but I think you can see from this that in caps he says, I want my money and I want it this week. And this is an email dated September 20th, 23, correct?
Correct.
And then it's the next day, September 21st, that a check is issued to Mr. Corbett for $9,800, correct?
Correct.
So it took this email from Mr. Corbett threatening to sue the city, threatening to bring his attorney involved to get any payment to Corbett.
There were other conversations Hillary had with the owner of Corbett. There were other emails that are not presented here where he is communicating with Corbett, the owner. And then when Corbett, the owner, took this tone, it's when Hillary brought it up to Erica and Lamont.
And at that point, when it was brought up to Lamont Taylor,
And Erica.
is the first time that Corbett got an answer and got paid at least some of the portion of what was owed, correct?
Correct.
So it took having to go to, and I think Mr. Taylor was an assistant director?
Correct.
So it took an assistant director to get any movement to get Corbett paid, correct?
Correct. And they were both Lamont Taylor and Erica Brandt were familiar with the demolition of this when it first occurred in June of 2023.
Okay, but my question to you is about paying and Corbett's invoices, and that it took getting the assistant director's attention and threatening a lawsuit from Corbett to actually get paid even a portion of the work that nobody disputed, because Hawkins did get their demo, they did get the demo permits for Hawkins, correct?
Correct.
But it's not the assistant director's job to make sure that payment is rendered for services, correct?
He is listed on the routing form as one of the signatures.
But it's your job, it was your job to make sure payment was made at the end of the day, correct?
Yes, and the form would be filled out, sent to Hillary for signature, sent to Erica for signature. Erica would then send to either Lamont or David Gray.
But if you don't route the form, Mr. Taylor isn't going to know that Corbett needs to get paid, right?
Correct.
And you did not route that form until September 21st, correct?
September 20th or September 21st, yes.
Okay, so following payment of the Hawkins job, if we can turn to stipulated Exhibit 28 again. Again, that additional invoice was sent following Mr. Corbett's email threatening to sue the city, correct?
The September 25th email from either Kelly Corbett, which is the wife and co-owner of Corbett, to me.
Okay. Okay, and then if we can turn to stipulated Exhibit 29. So it looks like following yet another invoice that was sent on October 24th, 2023, you respond to them that they got it looks like they needed to break down the contract amount in the invoice. So you asked them to do that. But at no point did you tell them that you were refusing to make further payments because of the mass grading issue, correct?
Correct.
And if we can turn to stipulated Exhibit 2 again. And turn to page 3. So it looks like on November 1st, 2023, you let Corbett know that the invoice was processed and that, quote, your payment should pay out this week, unquote. Is that correct?
Yes, the last payment of the $2,900.
Okay. And then if we go to pages 2 and 3 of Exhibit 2, on November 3rd, 2023, Mr. Taylor, your AD at the time, asks Mr. Gray to check on the status of the payment, correct?
This is in section 2, page 2 and 3?
Pages stipulated, I'm sorry, it's Exhibit 2. I'm sorry, it's Exhibit 3. So if you look at page 2 of Exhibit 3, and, I'm sorry, 2 and 3, starts on page 2, Mr. Taylor asks Mr. Gray, David, could you check on the payment status? And that's based on an email that he was copied on November 3rd from, again, Corbett, saying, I still have no ACH in my account. Can I get an update on this, please? Is that right?
Correct.
Okay. So then Mr. Gray says that the invoice had just been submitted and had an invoice date of October 26, and that it takes 30 days to process, correct?
For construction invoices, yes.
Okay. But then if we go to page 1, Mr. Taylor says, unless I'm missing something, we have net 30 payment from the invoice date per city policy. According to the email chain below, Mr. Corbett was advised by Eric, quote, we processed your invoice last week. Your payment should pay out this week, unquote. Based on this, it is totally reasonable for him to expect a payment this week. We need to course correct this. Please advise. Correct?
This email from Lamont Taylor is in response to Hillary's previous email at the bottom of the page.
And essentially, Mr. Taylor is saying, yes, normally we have 30 days from the date of invoice. However, Eric said, we're getting you paid next week. And so at that point, it is reasonable for Corbett to expect payment next week, correct?
Yes, because I did a quick response, a jerk reaction to Corbett, stating, we processed your invoice. I assumed that it was a paper check, and that's how I responded to Corbett.
But even then, you did not want to take responsibility for that. I think you called it jerk reaction.
It was a jerk reaction to Corbett's email.
Okay. So let's turn to stipulated Exhibit 14. So I believe you just said it was a jerk reaction, but at the time, what you said to David was, David, just saw Lamont crazy email. We will not rush to Kim for a check for Corbett. Hillary will reply to Lamont in a few minutes. And Mr. Gray responded, I already talked to payroll and they have agreed to submit it for payment. And then the chat cuts off, correct?
Correct.
So even after Mr. Taylor, who was your assistant director, essentially said, you need to pay them next week because Eric told them they would get paid next week, you were still trying to delay the payment, correct?
I was delaying the payment because, again, a paper check is a special request to the R&B Finance Department. At the end of the day, any department that's making special requests multiple times for paper check reflects badly on the department because it looks like the department doesn't know how to route invoices.
But that was because you made a promise to pay Corbett next week instead of saying net 30 days is when you'll get paid.
Correct.
And then when Mr. Taylor was trying to fix the issue that you created, you said his email was crazy, correct?
Crazy meaning that they were trying to pay the last 10%, and responding to Hillary's question there, this contractor still doesn't have demo permits.
And those were the demo permits that they told you they didn't have, at least for New Bern Avenue, that you instructed them they could proceed on, correct?
Correct.
Mr. Juarez, who is Tiara O'Neill?
Currently, Tierra O'Neill's role in housing and neighborhoods, I believe, is direct employee to David Gray. She took Jamie Marks' vacancy.
Okay. And let's turn to stipulated Exhibit 22. It looks like you forwarded an email, again, the subject being 1940-1942 New Bern Avenue on December 19, 2023, because as of December 18, 2023, the city still had not fully paid Corbett, correct?
December 19th, last paycheck to Corbett was December 21st.
Okay. So the email you sent to her says, keep between us. What does that mean?
I'm assuming or trying to remember that she must have asked what the heck is going on with Corbett, and I just forwarded the email for her to read up on.
Okay, would you agree that keep between us seems to indicate that perhaps you had some culpability in Corbett not having received payment as of December 19, 2023?
What's the objection?
She's trying to assume what's in his head. I think he would need to testify as to what he felt or thought in regards to that statement.
Again, I'm just going by memory. Tiara must have asked me what's going on with Corbett, and I forwarded the email to give her a heads up of what had been going on.
So you don't think there's anything suspect about forwarding an email about an issue that involves you and an issue about payment to a contractor and then saying, keep between us?
No, because Tiara's role was at that point a direct report to David Gray, who was financing and invoicing.
Okay. Mr. Juarez, in the opening statement for the petitioner, I believe it was mentioned that you had not been disciplined, and I believe you mentioned that you had not been disciplined. Is that correct?
Correct.
Okay. And presumably, you were showing us your performance evaluation to show that you were successfully meeting expectations and generally you were doing your job.
Correct.
However, when you worked for a different department with the city, you had been disciplined then, correct?
Objection as to scope. What's the objection? Objection as to scope and relevance. None of that was mentioned in the grievance or in the investigation. That was, what, almost 10 years ago? It's not relevant at this point to this hearing.
It can still be used for impeachment, and Mr. Juarez is portraying himself as someone who was just doing his job, and I think we can show the specific kind of discipline that was issued. It really shows a pattern.
I asked him about, in his current role, I never asked him about his previous roles, whether he had received any suspensions.
Well, I don't recall the precise testimony. I'll allow the question only for impeachment purposes.
Thank you. Please turn to City Exhibit 1. So while you were employed with the Engineering Services Department, you were disciplined for failing to be present on a project, correct?
Objection is to relevance. Has nothing to do with the allegations in this particular case.
So, Mr. Hotto, I agree that the substance of the former infractions, especially if they're...
Microphone, please.
Can you limit your questions not to the substance of the former infractions, but my understanding is that you were trying to impeach a statement that was made that there were no former infractions. Is that correct? Or
Yes, but also to
disciplines.
establish the similarity of the issues that he was disciplined for.
Well, I have overruled the objection and allowed the continuing question only for impeachment purposes. And so I don't think the substance of the former infractions are relevant.
Okay. I will move on if I'm not allowed to discuss the substance. Okay, let's move to stipulated Exhibit 20, page 1. And this was a statement provided from Mr. Gray to Housing and Neighborhoods Director Emila Sutton, correct?
Correct.
And the first sentence on page 1 says, 4 different inappropriate behavioral occurrences that were reported to me or eyewitness regarding Eric Juarez, correct?
Correct.
Okay.
Objection as to hearsay. This is not a conversation between Mr. Juarez and Mr. Gray. So I'm going to object to him being asked about this particular document.
Well, this is a stipulated exhibit, and I understand the objection, but go ahead and ask the question that you were asking with regard to Mr. Juarez's knowledge.
Yeah, yes, Your Honor. It was admitted into evidence, so it is something that's in the record.
But that doesn't mean he's competent to testify on a document that he didn't create. He just read after the fact, and he's not. This isn't an email correspondence between him and Mr. Gray. This is a statement of Mr. Gray. Mr. Gray certainly can testify about it, but I don't think Mr. Juarez is competent to testify about something Mr. Gray wrote.
Can you repeat your question?
Sure. So you were dodging calls from another contractor, Steve Haddock of A&M Ventures in April 2023, correct? Because he had done some work that he still had not been paid for.
What's the objection as to form in regards to dodging calls?
Overruled. You answer, please.
I wouldn't say dodging. Mr. A&M Ventures was calling the front desk for Housing and Neighborhoods because he was unable to leave a voicemail at my desk line.
But you weren't returning his calls.
I had spoken to A&M Ventures weeks and few days before he called the front desk again.
And he was calling about work he had done that the city had still not paid him for, correct?
Yes, he was calling about the up to $100,000 projects and how he wanted a paper check instead of a direct deposit.
And he had not been paid. And that's why he was calling.
Correct. And the extra hoops that I had to create for a paper check instead of ACH per his request.
So just like with Corbett, you had a second contractor whose payment was delayed.
Objection as to form, just like Corbett? I'm not sure.
Overruled.
Corbett's,
The circumstances, I think he'd already testified, they were different. The questions you asked him about were different.
Overruled.
you may answer.
Yes, he was calling about a payment, and he had also informed me that he wanted a paper check since smaller businesses tend to deal in cash as opposed to direct deposit.
So you're always going to come up with an excuse for delayed payments, correct?
Objection.
Sustained.
Okay. Let's go to stipulated Exhibit 17. Pages 1 and 2.
I don't have anything.
You don't have an Exhibit 17?
It's blank.
It's blank in his notebook. I may have an extra.
Oh. It's 17 is located in section 18. Is it an email?
It says 14 on the bottom.
Thank you.
It is it starts with an email from you to Mr. Sargent.
Yes, that's filed under Section 18 of this binder.
She just handed you another
Oh,
one.
okay.
But the document says stipulated Exhibit 17, right?
At the header, yes.
Okay, so that's the one that I will ask you a couple of questions about. Okay. So this is the project with the washer and dryer that you were questioning, correct?
Correct.
And I believe you testified that you did not review the bid, is that right, for this project?
Karina asked me if I had reviewed the bid to the bidder rebuilding togethers of the triangle.
And you said you had not.
Correct.
And you said you'd not take a look at the RFP.
Correct.
Okay. So essentially, you didn't know what the particulars of this project were, correct?
The only particulars I knew, which was dated, was listed on his invoice, the spreadsheet that acknowledges what account number it's paid for, the owner's name, and total cost of project.
And you didn't know how this project was funded, correct?
I assumed that it was federally funded as the $100,000 projects.
Okay, so you made that assumption, but having not reviewed the bid or the RFP, you just didn't know how it was funded.
I made the assumption because the previous third-party contractor, Resource for Seniors, was paid from federal funds.
But Housing and Neighborhoods has different programs with different restrictions and different rules, correct?
Correct. They have local match funds, federal funds, and other funds associated.
So again, you made an assumption, but you didn't actually know how this project was funded.
No, because I assumed from the previous third-party contractor.
Ms. Lemons, could I ask you to move your mic a little bit closer to you so I can hear you when you speak?
Okay, thank you.
I don't have any other questions, thank you.
Any redirect?
I do. You were asked on exhibits 23 and 8 in regarding to Corbett proceeding. She had asked you if it would be reasonable to think that they would assume that you gave them notice to proceed. Were you given any instructions from anyone in your chain of command regarding the timeline of completion for this project?
Yes, Erica Brandon had relayed to both Hillary and our unit that she wanted duplex village demolition completed by June 30th.
At this point in time, when he was emailing you on June the 20th regarding Newbern, had Russ already been demolished?
It had not.
What was the order of the demolitions? Which properties were demolished? If you recall?
The 3 duplex units were listed. I would have to reference the contract to see each bidding line item.
On Exhibit 8?
Okay. So as outlined in page 1 of Exhibit 8, demolition of structures for the following properties is 1925 Hawking Circle, 1927 Hawking Circle, which is 1 duplex unit, 112, 114 Russ, and 1940, 1942 New Bern Avenue.
What were the first structures to be demolished?
It probably would have been 1925, 1927 Hawkins.
And that property was demolished, and that invoice was paid, well, that invoice was made on September the 9th, correct?
Yes,
And you were asked about an invoice for this property on July, but that invoice on July contained all of the properties, correct?
correct. The
And
lump
all of
sum.
those properties had not been demolished at that point, correct?
Correct.
Okay. So you asked them in your email to reissue it with just the Hawkins Street property.
Correct.
And the invoice date for the Hawkins Street property was September the 8th, correct?
Yes,
And they were paid September 21st, correct?
correct.
You were asked about Exhibit the 26. And that was the one we were just referring to. That invoice initially, let me see this one. I'm going to skip that because that was the exhibit that I was referring to. On Exhibit 28, you were asked about not paying this particular invoice, but isn't it true that Corbett was trying to invoice for $10,000 more than the contract price?
Correct.
They tried to invoice, you said in your email, for $39,750.
Correct.
Exhibit 8, the contract price was $29,950.
Correct.
Would that have been best practices to send over an invoice that was $10,000 higher than the actual contract?
It was not.
And you asked them to correct that, right?
Correct.
And not only were you not counseled or reprimanded for challenging contractors' invoices with inconsistencies, you were praised on your performance evaluation for that in Exhibit 7.
Correct.
On Exhibit 2, you were asked about the tone of Corbett's emails. At that point, once he sent this last email, it then went to conversations outside of this email thread with Hillary and Corbett, correct?
Objection to form. And that's not in evidence.
Your testimony is that Hillary and Mr. Corbett had conversations, email conversations, that weren't contained in this thread, correct?
Correct. Both email
Objection
and...
to hearsay.
Overruled.
Yes, correct, to both email and phone conversations.
You had testified earlier that you submit the invoices for approval, correct?
Correct. Once I fill out the form that references the account number, and then I attach the spreadsheet which references the funding, monies left, monies after the invoice, I would then submit it to my boss, Hillary Leacock.
And do you write the check or send the ACH for the payments?
That is one of the options you can click on the form.
So you actually can write the check?
I personally don't write the check. I just click on the form, and since I was there, I would communicate with the finance individuals stating the invoice coming, they prefer a paper check.
So finance issues the payments,
The R&B finance department, yes.
and they issue ACHs and they issue paper checks.
Correct.
You had indicated that there's additional paperwork that's involved with issuing paper checks.
Correct. Where David Gray has to reach out to who is now retired, Kim Waddy, who used to be the supervisor for R&B finance.
When do you know, or when do you check that box for ACH for the payment when you enter it into the system?
When I am processing the invoice the first time around.
Did you have any occasions where the contractor would change their mind after you had already sent that in or checked that box?
We were always trained in the department to ensure that the vendor had ACH, which is quicker than cutting a paper check, but realistically, it's preferred that they have ACH.
You were asked on cross about a payment not being made because the mass grading plan. Who told Corbett that those payments wouldn't be made because of the mass grading plan?
It was expressed to by them from me and Hillary Leacock.
There are two exhibits that I am going to have you reference. One is employee exhibit number 1, and the other one is stipulated exhibit 3 in the binder. So on your email, on November the 1st, on page 3 of Exhibit 3, where you told Kyle that you processed his invoice last week and his payment should pay out this week. On the second page of Employees Exhibit 1, it appears that he was paid the next day, correct? On November the 2nd.
Yes.
And what was he paid for on November the 2nd? What was the amount?
$17,155.
And at that point, he had already been paid $9,800, correct?
Correct.
How much remained after that date?
The 10% of the total contract, which was $2,995.
So at that point, he had been paid 2 payments equaling $26,955. One of them, a large lump sum of $17,155, the day after your email where you said he would get his payment.
Correct.
On Exhibit 14, there's a screenshot or an image of a chat, but there's no date. Do you recall what the date is?
It would have to be the same date where Hillary is emailing Lamont explaining that Corbett doesn't have all his permits.
Well, this date of the email is February 16, 2024. And in your testimony, you said that the last payment was made to Corbett December the 21st of 2023.
Correct.
Yeah. So if you don't remember, you don't remember. But do you remember when that you would have conveyed to David that screenshot there?
Yes, it would have been in December, the same time that I did the quick reaction to Corbett, informing him of his invoice being processed and paid out.
Okay. And the one that you're referring to was the quick reaction. You're talking about the December payment.
Correct.
Because the date of this invoice, this last one that was paid on December 21st, is November 15th of 2023, correct?
Yes.
So he couldn't have been complaining in Exhibit 3 about an invoice that he hadn't sent yet.
Correct.
I just wanted to get some clarification on Exhibit 22 regarding your email forwarding to Tierra O'Neill. Was there a conversation that occurred outside of this email with Tierra O'Neill?
There must have been where Tierra must have asked me about what's going on with Corbett.
Objection to what Ms. O'Neill may have asked as hearsay.
Sustained.
You were asked about A&M Ventures, and we had already talked about the process of needing the amount of time it takes for the paper check versus the ACH. Do you recall how long it was between his invoice and his payment?
I don't have to reference the actual invoice that was submitted through the third-party TCM.
So you don't know if it was in the 30 days or not?
We always try to pay it within 30 days.
And there's nothing in Exhibit 20 in Mr. Gray's statement to indicate that it hadn't been paid within 30 days.
No, there isn't.
Also, this, he says, back in April of 2023, was there anything in your performance evaluation regarding this or payments?
There wasn't.
Exhibit 17, I just wanted clarity on that. You had indicated that you knew the type of project because of the previous contractor. So just so that we're clear, this particular contractor, rebuilding Together of the Triangle, what was the program that he's requesting payment for here?
So Rebuilding Together would perform projects for senior houses up to $15,000.
And so this was the situation where they were requesting payment for, was this the washer dryer situation?
Yes, 408 Bolin.
Okay. And so you indicated there was a previous contractor. Was it for the same program?
Same program. Previous contractor was Resource for Seniors.
So rebuilding together the triangle was the replacement contractor? For the
Correct.
same program?
Correct.
And so when you said you assumed it was the same guidelines, it's because it was the same program? Is that your testimony?
It was the same program, senior home renovations, up to $15,000.
I have no further questions at this time.
Anything further?
Just a couple of questions based on the redirect. So the performance valuation, that was for all performance prior to June 2023, correct?
Yes,
Okay, so it would not have captured anything after June 2023?
correct.
And then going to Exhibit 1, page 8, looking for the routing form. Okay. Page 8, you have testified about the routing form, and I believe you testified about this form as well. Is that right? This is the form that you would begin to send for payment, correct? Once you
Yes.
receive an invoice?
The invoice routing form, yes.
Okay, so for this one, it looks like you received the invoice from PLM on 9/27/2023, if you look at page 6. However, the director had not signed the document, so you got the signed document on October 3rd, 2023, according to page 6. Is that right?
Correct.
But you did not route the invoice until October 19, 2023, correct? If you look at page 8, at the top of the page where it says date,
October 19th, and I have an invoice date error there as well.
okay. And then if we go to Exhibit 20, page 3, the last page, I believe Ms. Lemons was asking you about when you sent the team's message to David Gray about Mr. Taylor's instruction to issue a check. And I believe your testimony was that it wasn't until December. You didn't remember, but you thought it was December, right?
Correct.
But according to this, it says that you sent that team's message to Mr. Gray on November 3rd, 2023, correct?
Correct.
Okay. So is it fair to say that that was most likely about the invoice you provided an employee Exhibit 1, the second page, invoice issued on October 26, 2023, and not the invoice on November 15, 2023?
It could be invoice 2 then.
Okay, and then this writing that is on this employee Exhibit 1, that's your writing, correct?
Yes.
So this is not a city record. This is your record, correct?
The writing is my record reference from PeopleSoft Finance information.
Okay, but it's your writing.
Correct.
I don't have any further questions. Thank you.
Just limited. Exhibit 20, that team's message was, it looks like November the 3rd, correct?
Yes.
And you said that you're not gonna, what was that? We will not rush to Kim for a check for Corbett. Isn't it correct that he had just been paid the previous day, $17,155?
Correct. And Kim is Kim Waddy in accounting.
And what, the amount that was remaining was that 10%, correct?
Correct.
And that was $2,995?
Yes.
I have no further questions at this time.
I have no further questions, thank you.
Okay. Thank you, Mr. Juarez. It's 1 o'clock. Let's talk about, Ms. Lemons, do you have any idea how many more witnesses you have?
Yes, I have, I believe I have 2 more witnesses.
Okay. And what about this for the city?
We have 3 witnesses. We don't think it's going to take very long unless Ms. Lemons has a lot of questions for them.
Okay, I do have a hard stop today for myself personally. I have to leave by 4:45. So just keep that in mind. If, we run over and we have to have another date, we have to have another date. But I do want to make that clear. I think it's time for a lunch break. And how would 45 minutes serve? Or do we need an hour? Court reporter, Madam Court reporter? Okay. So let's take, let's try to take 45 minutes, given the number of witnesses that we have. Okay?
Thank you.
Thank you.
We're adjourned for 45 minutes. do you have other witnesses?
I do. I'd like to call Nicholas Dula to the stand.
Would you put your left hand on the Bible and raise your right hand, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. Thank you.
Ms. Lemons, the witness is yours.
Can you please state your name for the record and pull the microphone up to you?
Hi, I'm Nicholas Dula.
Okay. And what was your position and title at the City of Raleigh?
My technical position was Community Development Supervisor 2. I had 2 working titles during my tenure. I worked here for 6 years. My first working title was Program Development Administrator. And then my role changed about a year or so ago, or several months ago, to be the Compliance and Planning Supervisor.
Okay. Can you describe the nature of your responsibilities in your last position there?
Yeah, as a compliance and planning supervisor, my job was to lead the effort to create some federal strategic plans. The city receives funding from the U.S. Department of Housing and Urban Development, or HUD. We had to submit a consolidated plan, an annual action plan, and several reports and plans as a responsibility of receiving that funding. My team led that effort to create the plans and provide the reports. My team also managed grant contracts for the city gave subrecipient grants to nonprofit groups to provide public services to low and moderate income individuals. We led that effort. My team also did the compliance work. All the federal programs that we receive have federal regulations that we have to comply with as a city. And so we provided support, and we're kind of the subject matter experts for all the compliance items. My team also was leading the effort to establish the Section 108 Loan Guarantee Program. My team was responsible for being a liaison to the Fair Housing Hearing Board. The team was also responsible for the Human Services Agency's grants, about $1.2 million of grant funding to nonprofits. And we, as part of that, we worked with the Human Relations Commission Grants Committee to receive applications for that funding and make the funding awards.
Who did you report to in the Department of Housing and Neighborhoods?
I reported to Erica Brandt, who is the assistant director.
And who did you report to? How long did you report to her?
She was in that position the last several months. When our new director, Emma Sutton, came, we had an assistant director named Lamont Taylor. He left, and then Erica was placed in that, got that position. And so I began reporting to her at that time. I don't know the exact timeline of that, but.
So prior to reporting to Erica, you reported to Lamont Taylor?
Yes, ma'am.
And do you know approximately how long you reported to him?
Lamont came to the city during the pandemic. So I reported to Lamont. I would imagine, pandemic's in 2020, so for a few years, I reported to him once he was hired.
And how long did you report to Erica?
When Lamont left, I think it was 2020, 2023 maybe. But I reported to Erica after she filled Lamont's position. Again, not technically sure on all the timing, but for the last several months at least, because we changed my position in May of last year, and so probably about a year, I guess.
Okay. Did you have any involvement in the city's work with the nonprofit Families Together?
Yes, ma'am. Families Together, or PLM Families Together, is a local nonprofit that received funding for various projects through the city. I've worked with PLM Families Together on various projects. I was the grant manager or the contract manager.
And as a grant manager, did you know the parameters of what is funded for that project?
Yes, that was part of my responsibility as being the grant manager. We have different funding sources, local funding sources, federal funding sources. As the grant manager, you have to be aware of the eligible expenses because there are rules related to the funding source. And so that was part of my job to know that and make sure that the subrecipient PLM Families Together was complying with the rules.
Okay. Who was responsible for approving invoices related to Families Together?
I'm assuming you're talking about a specific grant that they received. Could you be more specific on the
Sure,
particular
yeah,
grant?
absolutely. So how many grants was Families Together a part of? What projects? How many projects were they a part of? Under the different types of grants.
Different types of grants. So again, during the pandemic, there was federal funding from a CARES Act, and the city received a lot of money to help respond to the pandemic. During that time, Families Together received several grants. One of the grants that they received was for a project at 1100 Athens Drive. And the only reason I mentioned that project because I feel like there was some overlap with myself and Mr. Juarez, but they had a host of grants that they received. So I don't remember all, but because they were a big nonprofit, they did good work. They had a good relationship with the city. They knew how to respond to our RFPs, and they were very successful at receiving grant awards.
So let's talk about the 1100 Athens Drive project that you did that Mr. Juarez was a part of. Can you describe the type of project that Families Together did for 1100 Athens Drive?
Yes, ma'am. They were, we were calling it, they were doing rehabilitation work. The property at 1100 Athens Drive was a 3-unit apartment building. They were using the building for transitional housing for families experiencing homelessness. They had received grant funding to make improvements to that building for that purpose.
Okay. And what was the parameters of that grant funding? What were the funds designed for?
Funds were designed, so these were community development block grants. They were special allocation under the CARES Act. They were designed to make improvements to the building. CDBG allows you to do several distinct activities. This is more of a public facilities activity, and so homeless shelters are considered a public facility. You can use funds to make improvements to those shelters.
And when you say improvements, what's covered under the improvements?
For that particular project, I think there was some interior work done, some work, just work to improve the structure to make it livable, habitable, but work included in some interior work, design work, some electrical work. We worked with a contractor named John Duncan. He was with, I want to say Triangle Construction Management was a company. He helped us, he would visit the properties, help us develop like a scope of work for some of these projects. But I don't remember all the specifics, but I do know there was a deck, there was interior work done with electrical and just more work on the interior to try to make it a livable unit.
Do you recall an issue regarding washers and dryers being installed in that property?
Objection. I believe the line of questioning is actually about a different contractor, according to what Mr. Juarez testified to.
Is that correct?
If we look at Exhibit 17.
That is correct. I'll get to that in a second. Did you receive any complaints about delayed or missed payments from families together while Mr. Juarez was working on this project?
Sure. So I did not receive any complaints about delayed payment. I know the executive director and the finance director at Families Together. The project that we were working on, I initiated by creating the request for proposals, got through the funding award. This project then was handed off to Mr. Juarez to manage after that. So I was involved with knowing the parties or the representatives from PLM Families Together. I had worked with them on other grants, and so I feel like we had a good working relationship, and that if they needed help or there was some kind of hardship, they would contact me just to be like an advocate for them. But that didn't happen. Again, once the role changed, Mr. Juarez was just responsible for being the contract manager. But after he took over, I didn't receive any comments from PLM Families Together about the grant.
I'm going to direct your attention to Exhibit 1.
Stipulated one.
Stipulated Exhibit 1. Okay, and if you see on the top right-hand corner, it says page 1 of 13. I'd like you to turn to page 4 of 13. And it looks like you were CC'd to this email regarding Families Together. Were you involved at all in this invoice other than being CC'd there?
I was not involved with this invoice. I kind of stayed in the loop just because I handed off the project to Mr. Juarez and Mr. Leacock. I think I replied to this email saying, because I was not the direct supervisor for Mr. Juarez or Mr. Leacock, saying, hey, Erica Brandt is your supervisor, so she needs to be involved with approving any grants or any payments for this particular grant project.
And who was it that was asking about approval for this invoice?
The emails from Mr. Juarez.
Mr. who?
On this page 4 of 13, it's from Mr. Juarez, and he's saying Hillary attaches the invoice.
And so they included you in this email regarding this invoice, but you didn't have any other, there were no concerns or complaints about it after you received that email?
From what I see on the page, there's not a lot of description about, like, I don't remember what the invoice was concerning. I just know that, you know, after Eric took, or Mr. Juarez took over the contract, I was no longer in the, like, approval chain for that. Could you tell me more about what was included in that invoice, or?
Objection.
Same.
You only testified to your knowledge, and so you remember receiving that on that second page of the thread, right? On page 4 of 13.
Yes, ma'am.
Okay. And you weren't in the chain of command, so it doesn't look like your name appears anymore in the email threads, correct?
Yes, ma'am.
And that email thread looks like it starts on page 3, ends on page 4, and then there's the invoices.
Let's take a look at page 3.
And let me ask you this, on page 3 of 13, I see you reading that. It looks like it's David Gray to Eric and Hillary saying, I'm submitting this invoice, but we have to get better. This invoice is dated 9/27/23. Today is 10/25/23. This will not get paid by 30 days, and if audited by HUD, we will be required to pay these funds. The turnaround on these invoices needs to be quicker. On this particular project, was it a HUD project, or were HUD funds involved?
Yes, ma'am, because it says in here with the attachments, the CDBG, CV, CDBG, Community Development Block Grant. The CV denotes that that's a special allocation from the CARES Act. Part of our policy with the city was to make sure, well, part of like federal policy, CDBG, like HUD, federal regulations, is that invoices funded with this type of funding be paid within 30 days. And so that's why David is saying we have to like move forward, because we're using this funding source to make the payment.
And so flipping back on, I saw you looking at those invoices. You see on page 5 of 13, the
Yes,
invoice date. And what's the invoice date there?
See, October 3rd.
Okay. And looking for the payment, I believe it was it says on page 8 of 13, it looks like there's an authorization there on 1025. And that's page 8 of 13. I
Page 8 of
think you're
13.
passing it
Yes,
there.
ma'am. Gotcha. This is our invoice routing form. This is an internal form that we use just our had a fiscal like team in the division. It's Community and Small Business Development Division. And then they would use these to get the, as documentation of the account streams, like which fund the fundings were coming from, who was paid it, have dates. Part of HUD regs, they want to make sure that it requires a lot of documentation, and so we use it. This is part of some of that, for some of that documentation purpose.
Okay. And to your knowledge, did Families Together tell you that they did not get paid within 30 days of October the 3rd?
I didn't receive any communication from Families Together related to any issues of non-payment.
Okay. You had testified earlier, and I got ahead of myself asking you the question because we were on Exhibit 1. But you had testified earlier that you, part of your job was responsible for managing some of these grant-funded, federal-funded programs.
Yes, ma'am.
Okay. Were there, let me ask you. Are you familiar with the contractor rebuilding together of the triangle?
I am. Again, I was not like directly related to like the programming that they were involved with, in the sense that I was managing their programs, but they did a rehabilitation program for the city. There was a limited repair program where they would, I think it was aimed more at seniors, and they would provide funding to make repairs to homes. Folks applied through them. If the funds were awarded, then the city would work to make the repairs.
What was the scope of the repairs under that program for seniors' homes?
Again, we had each of the projects. A lot of times, how this works is we have a contractor who creates the scope of work for us, but it's mainly to do repairs to the structures of the properties there, so.
So it wouldn't include any, like interior design, for example?
Usually it's the fix, something that's broken. To qualify for the program, there has to be evidence that something's in disrepair, and you are fixing those items generally. That's what the program does.
So under that program, were washers and dryers typically something that would be placed in the home under that program?
Objection. There are several projects, and it's vague as to what program petitioner is referring to.
Does the project name Raleigh Home Revitalization BRT Corridors sound familiar?
So again, that's another one of our rehab programs.
Okay.
That the city funds. I do think that program may have been funded with local funds, but it was very similar to our like federally funded rehab program in the sense that it was designed to help homeowners make repairs to their home.
Okay. And under that program, did you guys provide washer and dryers for that program?
Objection, lack of foundation. There's no testimony that Mr. Dula managed that program.
Sustained.
Did that program fall under your supervision?
I did not supervise that program we provided support from a compliance piece, we provided support to program managers if there was a question about compliance, but direct program management would be with a different program manager. We had folks assigned to each project.
Okay. So in terms of compliance, did you in terms of 408 Boland Court, did you provide compliance information for that piece of property?
That, if there was a compliance question, for any project that we do, if there's a question about whether something complies or not, my team leads the effort to find the answer. And so, if there was, like I said, I don't remember all the projects where we, like the specific like addresses and projects that we provided support for, but if there was ever a question about if something was eligible, that would come to my team. So we could have provided support for that item.
Did you have any conversations with Mr. Juarez regarding washers and dryers and whether or not they're compliant with one of the programs that you provide compliance advice for?
Yeah, so generally we do some of our rehabs with federal funds, and particularly community development block grant fundings. we do not permit for that type of funding, washers and dryers to be purchased. There's a code of federal regulations. There's Chapter 24 deals with the U.S. Department of Housing and Urban Development. There's a Part 570 dot 207, and it talks about ineligible activities. And under that, it talks about the purchase of equipment, and it says that personal property, furnishings, motor vehicles are not eligible. And so it does go further to say, like, if the equipment is an integral part of the structure, like HVAC or, kind of the fixture for your water to run out, it's part of the building, that's eligible. But as far as like something that can be removed, like a furnishing or personal property, it says that is ineligible. So for those programs, I would advise folks not to allow for the purchase of that.
Okay.
Am I allowed to ask a question here? I'm a little new to this. I don't think you answered I didn't hear or I missed it. Did you answer, did you have a question with Mr. Juarez about the washer and dryers that she asked? I didn't hear if you said yes or no.
I don't, for that particular, I don't recall all the questions that my team receives, but I was just generally stating that if we were funding a rehab project with Community Development Block Grant funds, I would advise that team not to purchase a washer and dryer equipment, because based on my interpretation of the Code of Federal Regulations, that is not an eligible activity, and it's not compliance with the HUD guidance.
That's all the questions I have right now.
Thank you. I just have a couple of questions. Thank you, Mr. Dula. I understand you were subpoenaed to be here today, and I know your time is precious, so I'll keep it short. When you were testifying about CFR or the code, you were referring to federal regulations, correct?
Yes, ma'am.
And you would agree that federal regulations only apply to federal grants, correct?
Yes, ma'am. If we're using the federal grant to fund that
Okay.
project.
And if I understood your testimony correctly, you did not manage the 408 Bolin Court rehab with rebuilding together of the triangle.
I did not. Again, my team just provides like the compliance support for those projects.
And so you weren't aware of what funds were being used for that particular project, correct?
I don't recall what funds were used for that project.
And that's fine if you don't. I just wanted to make sure that the commission understands your testimony today. Thank you very much.
And redirect.
In regards to the program that you would have interacted with Mr. Juarez and provided him with advice on that particular property, was it your understanding that that was a federally funded property that he was inquiring
Objection
about?
to the mischaracterization of the testimony that was just provided.
You had testified that you did speak about a compliance matter with Mr. Juarez regarding washers and dryers, correct?
Yes, ma'am. I feel like questions, I do remember receiving a question about the purchase of washer and dryer. And that's why, I've researched the HUD regs and provide guidance. And that guidance was, if it was funded with the Community Development Block Grant Program, that would not be an eligible, purchase.
You said if it was funded by which program?
If it was a federally funded program, specifically the Community Development Block Grant Program, then I would always advise against the purchase of that, just because the HUD regs don't allow for that.
So you say it's called the Community Development
Block grant.
Block Grant?
Yes, ma'am.
Okay, and is that Community Development Block Grant used for different programs?
It can be. You can do rehabs with that funding. Yes, ma'am.
So for home renovation projects, do you know if those fall under that grant?
Objection to the vagueness of the question. Mr. Dula already testified about various projects, and we don't know what project the question is asking about.
Okay, specifically, I was asking about the home renovation projects that you testified to.
Objection, again, the witness testified about several projects.
I'll sustain it.
All right. You did mention, did you testify to the revitalization project? I know they all have Rs, so I'm just trying to make sure I'm understanding your testimony correctly.
With some of the, like I said, each program had different funding sources. And again, with the federal funding, that's where the guidance of the ineligibility was. We had a limited repair program. I know we use federal funds for that program. We did have other programs because we receive housing bond funds, and those are local funds, and we had programs or projects that use those local funds. I think we tried to have uniform standards across our programs, but it would just depend on, like I said, hopefully there would be details for the very specific project to say this was this program, this was the funding source, and we would just advise based on what the funding source was.
Understood. Thank you.
I have no further questions. Thank you, Mr. Dula.
Thank you, Mr. You may step down. Ms. Lemons, call your witness.
Thank you. At this time, I'd like to call Tammy Nelson Donado to the stand.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you so much.
Please state your name for the record.
Tammy L. Nelson Donado.
And what was your position and role at the City of Raleigh?
I was hired January 4th of 2020 to be community development coordinator and project property manager for affordable housing, which the city has a portfolio of, and also as part of the construction unit headed by Hillary Leacock, I performed various functions, including invoices and participation in rehabs and so on.
Okay. And did you have the opportunity to work with Mr. Juarez?
Very often.
Okay. And how did you work with him?
We were a bit of a team, I guess you could say. He had some of his own things, and I had my own things, but a lot of times they would overlap. And so for the New Bern project, we worked together on that a lot, along with Hillary, and several of the rehabs.
What was your part of the New Bern project?
I would say a lot of support as far as things needing to be done and organized. I also worked on site a lot, making sure that things were happening at the right time. I worked with the people who were homeless that were occupying these units, these duplexes, and getting them to move. I worked with the property manager, which was contracted through the community development, Barker Real Estate, who handled lockdowns, and they also handled the initial move-outs for those properties because they were in horrible condition, subpar condition, and so being that there was going to be new construction on that site, we worked very hard to try and find new housing for those residents.
What was the structure of the department that you worked with Eric in?
We both worked under Hillary Leacock, supervisor. And above Hillary, at one point, his supervisor was Lamont, and then I believe it transferred over to Erica when she returned from, it might have been just before she went on maternity leave, somewhere in that time frame.
Okay. In your experience in working with Mr. Juarez, did you see any criticism of his performance within the department?
Within community development or within our team?
Within your team?
Within our team, no, there was no complaints. Eric worked very hard and worked a system. And he was also very, very much into detail. So, no, his work was impressive.
Okay.
Sometimes he was overloaded.
What do you mean by that?
Just a lot of things happening at one time that he would be actively involved in.
During the time that you worked with Mr. Juarez, was his department or his division fully staffed?
Oh, no, we were always down. We had, let's see if I can remember correctly, they were down 2 or 3 staff members when I got hired. And one that was there moved to a different department. So for a long time, it was Hillary and I. And then Mr. Juarez was brought on, so then it was just the 3 of us. And then quite a while after that, Darius Todd was brought in, he left, and then Patrick, I can't remember his last name, Patrick came in just about 6 months before I left. So we were always short-staffed, always.
Going back to the New Bern project, do you remember the demolition project on New Bern Avenue?
Mm-hmm.
And what was the protocol for the demolition?
The protocol for it, I wasn't involved in the actual contracts being, how do I say, managed, but I was part of the way they were drawn up and so on, and the processes that the contractors were supposed to take. And that was that each of the 4, I think there was 12 buildings, if I can remember correctly, and each grouping was awarded to a different contractor. In the agreement with each one of those contractors, the agreement was that they would get the permit, begin the work on one property, complete the work on one property, close out that permit, and not get the permit for the second property until the first was closed out. And then the same process with the second one, closed out, and then the third one.
Did you, were you involved at all in the project that, the New Bern Avenue project that, or the part of the project that Corbett Demolition worked on?
Mm-hmm.
Okay, and how did they follow that process?
Honestly, they did not.
Okay.
They went through the contracting and, or, the contract process with Eric and Hillary, because Hillary was overseeing all of this, and Eric was working as his second. What happened was on a Friday, they began work. And Hillary had observed that. When he left for work or went home that day, he said he was going to drive by on his way home. And his words to me were that all was well, they were doing the one building. No cause for alarm. When he came to work on Monday, he was in utter shock and frustration because that contractor was a subcontractor to Corbett. Or it was not Mr. Corbett that did the work, it was one of his, not subcontractor, but one of his other people that perform work. I can't think of the word.
Would it be, was employees or workers?
Like an employee, yeah, I think he was an employee of his, but Mr. Corbett was not on site. This man was covering the work being done. And he had completed all 3 of those properties in the weekend. And when Hillary came to work, which he said what he said, and then I went out and saw, I think Eric and I both went out in utter shock to the property and saw that all 3 buildings had been taken down in a matter of a Friday, Saturday, Sunday.
And do you remember which buildings? There were multiple buildings, I believe, in that project. Do you remember which buildings?
Off the top of my head, I couldn't give you the addresses.
There were some on
New Bern,
Russ,
and Hawkins Circle.
Okay. Do you recall which of out of the 3 that those buildings were? Was it New Bern, was it Russ, or was it Hawkins?
It was all 3. It was 3 properties. They were not contiguous to each other because that was the only way that we could accomplish the demolition without going to a mass grading process.
So by demolishing those buildings, did that trigger a mass grading process?
Yes, yes, it did, and it was very frustrating because all the work had been laid and, agreed upon by everybody, so it kind of just shut down any work that could be done on the other properties. Just shut them down, and those other contractors had to wait a significant amount of time, months, before they were able to perform their contract because of this.
Were you aware of whether or not anybody told Corbett to tear down all three at the same time?
No, it was never part of the process, never part of the process. It was always 3 at a time. What happened is
You just said it was always 3 at a time. Was it 3 at a time, or
No,
was it?
I'm sorry, I misspoke. 3 done separately. Each contractor but one had 3 properties. One contractor had 4. So they were always done building 1 with a permit, close it out. Then building 2 with a permit, demolish, close it out. And the 3rd the same way.
Were you involved in any of the concerns that Corbett had regarding being paid for that job?
Oh, yes, yes.
And what do you recall about Corbett's concerns about payment?
Well, the first thing was that he blamed it on his coworker and said that he was not on site and this person had done it. That's the way they had always done it.
Objection to hearsay.
Sustained. Don't talk about what other people said.
I was talking about what we were discussing in the office.
I can rephrase the question.
Okay, I'm sorry.
So, in regards to what to your knowledge, or did Corbett have any concerns about receiving payment for that? Without telling me what somebody said.
Corbett wanted payment for it, and they were quite belligerent in asking for it. Hillary and Eric tried to work through this problem because the permits were never obtained. So the properties were demolished. I don't know if the right word is illegally, but the permits were never attained for them. And then the buildings were demolished. So this was against the contract. And yes, he wanted payment, but we were in a position where making payment for something that was done incorrectly and incompletely was inappropriate. And so there was a lot of issues about, do they get paid, or do we ask them to get the permits and complete their work before we issue payments, and so on. There was a lot of that going on, and Hillary and Eric very much did not want to sign off on this because the contracts that they had negotiated did not allow for this.
Who ultimately, if any, did anybody ultimately sign off on payments to Corbett?
The only thing I know, and I know it because some of the discussion happened with me at my desk, so it's not, it wouldn't be considered hearsay. I heard Lamont at my desk saying, just pay it. We don't want this monkey on our back. It's just going to cause us an amount of trouble. We've got an invoice that needs to be paid within 30 days. Just get it done, and then we'll take care of the fallout afterwards.
Do you recall when that was?
Well, it was before they were paid. I can't testify to anything more than that. It was prior to them being paid.
Okay, all right. Were you working at the department when Mr. Juarez was terminated?
I was.
Okay. And did you receive any notice regarding the termination?
No. It happened as a total surprise. We were in a, do you want me to go on? I'm sorry.
Yeah, you can.
I don't want to overtalk. We were in a staff meeting discussing several projects, and Ms. Sutton came into the office and asked both Hillary and Eric, if I'm remembering correctly, or Hillary was late to the meeting. He was at his desk. Eric was there, and she told him to please stand up and gather all of his items and leave the room. And the rest of us were told to stay in that conference room and not to leave.
Okay. And was there anything about that that was different from, or was there anything from that experience that caused you any concern?
Caused me great concern. This was my team that I had been working with. I had been working with them for a long time. I knew them to be very particular in the way that they worked, but I was not told that they had been escorted out until after the fact. And yes, it upset me greatly.
I have no further questions at this time.
Good afternoon, Ms. Nelson Donado.
You can just call me Tammy. Whatever.
Thank you for being here. Thank you for taking the time to be here today and provide your testimony. I just have really one or two questions. There should be, and I apologize, but there's a notebook to your left. And if you wouldn't mind turning to stipulated Exhibit 23.
Okay. Stipulated Exhibit 12, 13, 14, 21. Okay.
And that, as you can see, it's a two-page email, and it doesn't look like you, it looks like you might have been copied. If you look at page 1, June 21, 2023.
Yes.
Do you recall receiving that email? Mr. Juarez copied you, it looks like, and it says you can move forward with the demolition schedule.
Okay. Yes.
Okay. And so it does say, yes, you can move forward with the demolition schedule in reference to New Bern Avenue?
That's what it says, yes.
Okay. I don't have any further questions. Thank you.
I have a few questions. What is the date on this email?
It started Wednesday, June 21st, it looks like, or June 20th, Tuesday, June 20th. I'm sorry.
And do you recall if there were any buildings demolished before that date?
I do not. It took quite a long time, and being told that you can move forward with the schedule would include the permits, each one of them done. So being told that you can move forward with the schedule would not be property specific. It would be more or less just using that address as one of the three.
So moving forward with the schedule, what would that normally entail, moving forward with the schedule?
Moving forward with the schedule, they say here that they had a permit. So apparently they did get the permit to do the first property, but they did not get the closeout permit and the new permit for the second and the third properties. So they asked permission to get started, but they got started and did all three at the same time.
And
Same weekend.
And so when you see that, when your understanding of a demolition schedule, the way that you all do it at Housing and Neighborhoods, or did it when you were there, the process is, you said permits, then what's the next step?
Permits, making sure that all utilities and so on are dismantled, removed from the building, and then just careful demolition to make sure that things don't go wrong.
And then after that, the next step would be?
Close out permits. They'd have to do one step I forgot about was they were also to seed and straw the ground that they had just disturbed before they walked away from the property and moved on to another one.
Okay.
So, and that's something that we had in every contract was seeding and strawing, or in most contracts. I can't speak for everyone, depending on it.
And to your knowledge, did Corbett follow that?
No.
With this project?
No, they did not. When we got there, it was a mud hole that was in big disarray.
I have no further questions.
Anything further?
I have nothing further. Thank you.
Thank you.
Thank you.
That's all the witnesses. That's all the witnesses that we have at this time.
So, Ms. Gross or Ms. Donado, are you ready to call your first witness?
We are, Your Honor.
The city's first witness will be Miss Erica Brandt.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good afternoon. Could you please state your name and business address for the record?
Erica Brandt, business address is 421 Fayetteville Street, Suite 1200, Raleigh.
And what is your position with the city?
I'm the Assistant Director for Housing and Neighborhoods Department.
And how long have you held that position?
I've been in this role for about a year.
And did you have any previous positions with the city?
I did. When I was initially hired with the city in February of 2022, my position was Housing Programs Manager, and then I was promoted to Housing Programs Administrator prior to Assistant Director.
And what is your current role as Assistant Director? What do you do in that role?
Yeah, so our department is responsible for improving the quality of life for Raleigh residents by increasing the supply of affordable housing in the city, improving access to affordable housing, which includes ending and preventing homelessness, and enforcing city codes to ensure habitability. And so in my role, I oversee teams that do that work. Specifically, the teams I oversee administer housing programs, they implement homelessness response programs, provide care navigation services as part of the city's new Raleigh Cares program, an alternative response program, and perform planning, reporting, and compliance duties.
Thank you. And I'd like to direct your attention, if we could turn to stipulated Exhibit 11 in that binder. Are you familiar with this document?
I am.
And you issued this pre-termination notice to Mr. Juarez on April 30th, 2024, is that correct?
Correct.
And were you out for a period of time prior to issuing this notice?
Yes, I was out from December of 2023 through sometime in March 2024.
And did you supervise Mr. Juarez prior to your promotion to assistant director?
He was in my chain of command, so I supervised his supervisor, Hillary Leacock.
And when this notice was issued on April 30th, 2024, what was the basis of your decision to issue this?
So while I had been out on leave, there had been an HR investigation conducted into Mr. Juarez and Mr. Leacock concerning issues of gross negligence, violation of city policies, and conduct issues. And the result of that HR investigation found that Mr. Juarez had knowingly issued a notice to proceed to Corbett Construction and then knowingly violated city policy and withheld payment for services rendered, in addition to some other issues that were investigated. And the result of that investigation recommended preterm. After considering the facts of the investigation, I stood with that HR recommendation.
And did you conduct a hearing prior to making your final decision?
Yes, a pre-termination hearing was held in May.
Could you explain the process of that a little bit, please?
Sure, yeah. So this is pursuant to the city's policies for disciplinary actions, that whenever a pre-termination notice is issued, a hearing will be held, and the employee is given the opportunity to present any evidence or other documents or what have you that would sway the decision to terminate. So we held that hearing in May.
And you just testified that the employee could bring any documents or anything to that hearing. Did Mr. Juarez provide you with any information during that process?
Not that I recall.
And did Mr. Juarez bring any witnesses to that hearing?
No, not that I recall.
If he had provided you additional documentation, is that something that you would have considered in your decision?
Yes, absolutely. That's the purpose of the hearing.
And following that pre-termination hearing, why did you consider termination to be the appropriate disciplinary action?
Yeah, so I arrived at the conclusion that termination was really the only appropriate disciplinary action, disciplinary remedy, because of the gross negligence that had been displayed in this case. The city was put at risk of litigation. Our reputation with contractors was damaged. And several city policies were violated, as well as core organizational values around trustworthiness, integrity, and honesty. And that, had been violated as he had lied to cover up his mistakes.
And you testified, you said, I think the only appropriate action was termination. Did you consider any discipline that was less than termination?
Certainly in my head while I was thinking about what to do here, right? And I arrived at the conclusion that that the only appropriate disciplinary action in this case was termination because of the reasons I just gave, and the investigation had shown a certain pattern of that kind of lack of integrity and violation of city policy and trust. And so I had no basis or reason to believe that if he were brought back into the department that he would not continue to behave in that way.
And Mr. Juarez, in his appeal, contends the real reason he was terminated was for whistleblowing. Is that accurate?
That is not accurate.
Why not?
Is this around the washer dryer thing?
Yes.
Okay. Can I
Yes.
explain that
Yes,
situation?
please give
Sure.
some context.
So I think it would be helpful for everyone to understand the 3 different programs that our department has with regards to housing rehabilitation. We have 3 separate programs. They are different in size, different in scope, and different in funding source. At the high end, we've got the Substantial Rehabilitation Program. Mr. Juarez referred to that as the program that provides loans of up to $100,000. These are specified for folks who are either senior or disabled. They have to have at least 3 major failing systems in their homes. They're large-scale repairs. And because of the scale of the repairs, they're kind of bare bones. It's really just to address major life safety, health hazard type things and failing systems. That program is federally funded with both community development block grant funds and another HUD program called the HOME program, both federal funds. On the low end, we've got the limited repair program, which provides loans to anyone. There's not a disability or age requirement who meets the income eligibility, and that goes up to $15,000. The only major difference between those 2 programs is just the dollar amount and the kind of scope. So they only have to have 1 failing system for the limited repair program. Typically, it's like a roof replacement, an HVAC replacement, something like that. And then in the fall of 2022, City Council approved a 3rd new program, the Raleigh Home Revitalization Program. That program is not federally funded. The other 2 programs are federally funded. The Raleigh Home Revitalization Program is funded with local dollars, the 2020 Affordable Housing Bond, and that program was specifically designed to sort of fill in the gaps between these other 2 programs. So there's not a set dollar amount target, and the program guidelines are really made to be flexible. In the program guidelines that was in the RFP that was issued to select Rebuilding Together as the program administrator, we give examples of some things. We include things like cost-effective, energy-efficient repairs, replacing water heaters, bath fixtures, et cetera, painting inside and out. It does include the ability to do more cosmetic procedures with the aim of improving the property value and retaining the property value. These funds are targeted toward long-time homeowners living in the BRT area, so it's kind of an anti-displacement program to kind of get out ahead of some of the anticipated gentrification in those areas. And then there is also specified in that program guidelines that if a proposed improvement or repair is not present in the above list of examples, but would accomplish the goals of the program, the city can approve it. And so the washer, this, to be clear, the 408 Boland Court project was funded through the revitalization program. So that's local funds, no federal funds involved. The funds were used as directed by City Council and within the guidelines of the program guidelines that were issued in that RFP and that staff had access to the program guidelines. I received an email from Eric while I was on leave asking about the washer dryer. In that email, he notes that the funding source is bond money, local money. I was on leave, so I forwarded that email and just asked for somebody to touch base with Eric and clarify that this program is not the same as a substantial rehab program. I'll leave it there.
Thank you. If we want to turn, you just referenced the email, so stipulated exhibit. I believe it is stipulated exhibit 18. Is that the email that you were referring to? I know there's a lot of emails in here.
Yeah, so the email at the bottom of the page that goes over to the second page is the email I was referencing.
Thank you. And you previously heard Mr. Juarez's testimony today and stated that you wanted Duplex Village to be completed by a certain date. I believe it was June the 30th. Do you remember that testimony?
I remember that testimony, yes.
At any point, did you require the project to move forward if it was contrary to the terms of the contract?
No. And the project deadlines were set, as part of the performance evaluation process the prior year, right? So that goal was kind of set in July of 22.
Thank you. If we could turn to stipulated exhibit 10. Do you recognize this document?
I do.
it's titled termination notice, and in this termination notice, you noted that Mr. Juarez put the organization at significant risk, and you previously testified a little bit to that. Could you please explain more what you meant by that?
Yes, so by withholding payment and ignoring calls, not communicating transparently with the contractor about the circumstances that led the contractor to send that long, angry email threatening litigation to the city. So the actions here put the city at risk of litigation.
Thank you. No further questions right now. Thank you.
Ms. Lemons?
I have a few questions. So prior to, you were there from June, during the June through December, correct, of 2023?
Correct.
What day did you actually go out on leave?
I believe that would have been December 5th, 2023.
So prior to you going out on leave, let's see. Sorry. Prior to going out on leave, you were aware of the Corbett contract, correct?
I don't recall exactly when I became aware of the issue. It would have been sometime perhaps after September in the fall of 23. I would have to go back and look at those emails to see when I was looped in.
When you had indicated that Mr. Juarez put the city at risk of litigation, there were other people in his chain of command that had to approve the payments, correct?
Correct. That is how our invoice process works.
Okay. And so he didn't have the final say on those invoices, correct?
He would have initiated submitting the invoices, but he would not be the final approver.
And he didn't actually issue the payments?
No, our finance department with the city does that.
Were you aware that Corbett had demolished several buildings without authorization?
I am now. I mean, what time frame?
Based on the testimony that you just heard from Ms. Nelson Donado?
I became aware that there were issues with the project sometime in the fall of 2023.
So that was prior to you going out on leave?
Correct.
Okay. And what did you do in response to that?
In response to what?
Becoming aware that there were issues with the project in the fall of 2023?
I sought clarity on what those issues were from Hillary Leacock, who is my direct report.
And what decision did you make in regards to the issues once you assessed what they were?
Well, once I became aware that Mr. Juarez had provided the notice to proceed, knowing that the permit had not been issued, that was of concern. I was not involved, I don't believe. I think that the conversation about issuing the rushed payment occurred after I was out on leave.
So if you became aware of the issues with that property prior to you going out on leave in the fall, why didn't you do a write-up or any type of disciplinary action for Mr. Juarez at that time?
He is not my direct report.
But you indicated that this incident warranted termination.
After the HR investigation, the results of the investigation came out in February or March, or whenever that was, of 2024, after I had returned from leave.
My question is if it wasn't urgent to rush and terminate him in the fall of 2023, why was it so urgent to terminate him in February of 2024?
Due process. We have to find all the facts, right? The HR investigation had to be conducted to determine what exactly had happened, what the pattern of behaviors were, before a decision like that would be made.
In order to do a write-up, do you have to go do an investigation to do a write-up or a written warning?
No, but write-ups are typically issued, disciplinary actions are typically issued by the supervisor, the direct supervisor of an employee.
And did you instruct his direct supervisor, Mr. Leacock, to issue a written warning?
There were personnel matters at hand with that supervisor.
If there were personnel matters at hand with the supervisor.
Objection. Under 160A, 168 Personnel Privacy Act, those matters are privileged information and have not
I'm
been
not
released.
asking you about that.
Let her finish her question. Go ahead.
So if there were personnel matters involved with the supervisor, then wouldn't that leave it to you to do the write-up?
No.
And why not?
I mean, it's a personnel matter. I'm not sure what I can say about
The write-up for Mr. Juarez, we're here on his case.
I'm aware, but it involves a personnel matter with his supervisor. I'm not sure what I can say about that.
My question is if the supervisor was not an option, if Mr. Juarez's direct supervisor was not an option for doing his write-up and you were in his direct chain of command, wouldn't you be the one to do the write-up?
So,
Ms. Brandt,
yeah.
if the answer involves any privileged personnel information under 160A, 168, you're not allowed to discuss that information.
Okay. I will just pass.
I'm not asking specific personnel information about his supervisor. I'm asking specifically about Mr. Juarez and why Ms. Brandt didn't do the write-up for Mr. Juarez if there were issues with his supervisor.
I think it's okay for me to say that the supervisor was supposed to do a write-up or should have done a write-up.
Can I offer a clarifying point real quick? I don't know if that's allowed. So if Mr. Juarez wasn't or was unable to go to his direct supervisor at the time, who would have been his alternative report?
That would have been me, right? Yes.
Got it. Thank you.
Thank you for breaking down the different programs that the department has in regards to the rehab programs. You had indicated that the 408 bowling court was locally funded?
That's correct.
And to your knowledge, was the contractor paid for that, including the washer and dryer?
I don't have any knowledge of them not being paid.
Okay. Did you bring the issue of Mr. Juarez to Lamont, your direct supervisor?
Yes.
Okay. And did he advise you to write up Mr. Juarez?
No.
Okay. And why not?
I can't speak to his reasoning.
Don't talk over each other. You have an objection. The objection is sustained, but ask the question. You can ask the question if she knows.
Okay. So in regards to Mr. Juarez, did your direct supervisor, Lamont, instruct you to do a write-up for Mr. Juarez?
No.
Okay. That's all I have for now.
Any redirect?
No further questions. Thank you. Thank you, Ms. Brandt.
Oh, sorry. Commissioner has a question.
I have two questions. First, referencing stipulated Exhibit 11, the pre-termination form. At the bottom of the first page, under personal conduct, the box J is checked, refusal to accept a reasonable proper assignment for an authorized supervisor. Would you explain more about why that box is checked?
Are you on Exhibit 11, did you say?
Yeah, stipulated Exhibit 11, page 1 of 3.
All right.
Yes, that was in regards to the insubordination against issuing the payment. So that back in, I guess it was December of '23 when Mr. Taylor, who, this was while I was out, but Mr. Taylor had issued instruction to Mr. Juarez to make the payment that day that had been promised to be made that week, or whatever that time frame was. And then in response, Mr. Juarez sent the message to Mr. Gray saying the email was crazy and not to do it.
All right. My other question, if you're supervising a supervisor who, for whatever reason, cannot perform the duties that he or she is assigned, illness, personal leave of absence, whatnot, do you believe it's your responsibility to fill the gap if a lower down performance issue arises?
Absolutely, yes. And I will say that the best way to fill the gap is by coaching and developing the supervisor, right, so that they can do their supervisory duties.
All right. No further questions.
Any other questions or follow-up? Thank
I-
you so much. Oh, you have one?
I did have. So it's your testimony that it is because of that team chat that Mr. Juarez sent regarding the payment on November the 3rd? That's the reason you have for insubordination?
Correct.
I have no further questions.
A quick follow-up. I believe in the petitioner's line of questioning, what Ms. Lemon was sort of alluding to was, in essence, right, you were sort of the acting supervisor for Mr. Juarez, is that correct?
Yes.
And in that capacity, one of your responsibilities as acting supervisor.
Sorry, are you saying I was acting supervisor when I returned from leave? Yes.
What about prior to?
No, Hillary Leacock, Mr. Leacock was still there
I
and was
see.
his supervisor at that time.
Got it. Okay.
Yeah. I would not say I was acting supervisor in any way.
Right, right. Okay. So, but prior to that, Mr. Leacock was still in that capacity?
Correct.
Okay.
Yes.
Thank you.
Yes.
Having no further questions, thank you so much.
Thank you.
Next witness.
Miss Emma Sutton, please.
Stand on the Bible and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you so much. Thank you.
Good afternoon. Could you please state your name and business address?
Emma Sutton, 421 Fayetteville Street, Raleigh, North Carolina.
And what is your position with the city?
I serve as the Director of Housing and Neighborhoods for the City of Raleigh.
How long have you been in that role?
Just over a year and a half.
Could you please describe your role as Director of Housing and Neighborhoods?
So I direct all the divisions within the department to include code enforcement, community development, and at the time, neighborhood enrichment, as well as we have a small business team.
Ms. Sutton, could you please turn to stipulated Exhibit 31? And it'll be on page 2. Do you recognize this document?
Yes.
Page 2. And according to this, you issued Mr. Juarez a response to his appeal regarding his termination notice that was received on May 22nd, 2024, correct?
Yes.
And what was the basis of your decision to uphold Mr. Juarez's termination?
The basis of the decision was the information provided from Mr. Juarez at the appeals hearing combined with the report and investigation provided by HR.
And was a hearing conducted prior to making that final decision?
Yes.
And could you explain the process of what went into that and what went into your final decision?
Yes, sure. So pursuant to city policy, Mr. Juarez was able to meet with me and appeal the termination decision. That gave him an opportunity to provide any additional evidence or witnesses.
And did he provide any additional information or witnesses?
No. Well, there may have been, he spoke, so he provided information, but there were no witnesses.
What information was provided by Mr. Juarez?
I think similar to what he provided here. It wasn't anything, in my recollection, that was substantive, that would at all change the facts at hand. There remained a lack of accountability.
What do you mean by a lack of accountability?
Mr. Juarez was not admitting to or accepting fault in any of his actions or conduct.
What was he at fault for?
The issues of insubordination as well as gross negligence, and there were also some conduct issues.
What do you mean by gross negligence?
Gross negligence would be his action to allow for the demolition to proceed on the property knowingly when it did not have the proper permits in place, putting the city at legal risk, but also, putting our work at risk in the sense that actions like that can be site limiting, so it can actually determine and limit what we can do on that site as far as development of affordable housing.
How does that affect the mission of housing in neighborhoods?
I'm sorry, repeat that.
How does that, what you were just referencing as site limiting, affect the mission of housing in neighborhoods?
I mean, I would say in general, it just makes our work a lot harder. It could potentially impact the funding sources that we can utilize at that property. There are a number of factors that go into site suitability and viability, and something like that can impact those factors and then sort of stifle or determine what funding sources we could and could not use, or what type of building could be developed there.
Thank you. And jumping back to one of your previous answers, you mentioned a few reasons. One was gross negligence, which you explained. Another was insubordination. Could you explain that a little more, please?
Sure. The insubordination was Mr. Juarez's refusal to make the payment after Assistant Director Lamont Taylor asked for that payment to go through. That was based on that message provided by Mr. Gray, where Mr. Juarez stated, "That's crazy, we're not going to make the payment," against the instruction of the Assistant Director.
And following that appeal hearing, why did you consider termination to be the appropriate disciplinary action?
Again, there was nothing brought that would run counter to the facts at hand and the issues that happened. There was no convincing evidence provided or witnesses provided that would change any determination made by the investigation that HR provided.
And was any discipline considered that was less than termination?
Yes. I mean, I think we always try and consider anything less than termination. That is not the way that we want things to go in any situation.
In this situation, if Mr. Juarez was merely suspended per se, when he came back, would you have trusted him?
No.
Why not?
I think he demonstrated that he would fabricate information in order to protect himself. And I think he also demonstrated a history of lack of accountability.
And during this appeal hearing, what was Mr. Juarez's demeanor like?
It was patronizing towards me.
Could you please explain a little bit?
Sure. So there was one moment during the hearing, I was listening during the entirety of the hearing, and there was one moment where he leaned over the table and said, "You should write this down." And I felt that that was patronizing. His tone overall also was in that same sort of patronizing realm.
And you've heard a lot of testimony here today, and there was some regarding the date that the Corbett incident came to your attention. Do you recall what date that came to your attention, or thereabouts?
It was in February. I was not made aware until Lamont Taylor brought it to my attention, and that was because of the payment that was not being made. He felt like that should be escalated to me because of the tone and the tenor that was coming from the contractor.
And if it was escalated to you prior to that, would it have been addressed at that point?
Yes.
Speculation. Overruled.
No further questions, Ms. Sutton. Thank you.
you had testified that at the hearing, well, actually, let me back up. You instructed David Gray to send an email regarding different incidences. And why did you instruct him to send you an email regarding different incidences regarding Mr. Juarez?
That's a good question. I don't know if I requested that he do that. David and I had a conversation. I approached David about the incident, about the payment, in order to learn more information. And within that conversation, David offered to me that there had been several instances of Mr. Juarez acting disrespectfully towards other staff. And he expressed that also that there was a history with Mr. Juarez of not making payments in a timely manner. And so that information was provided to me as evidence of that.
And it doesn't appear that that was a part of the findings in terms of the disrespect to staff. That wasn't a part of the findings, correct?
I don't know if conduct was included in the termination. I would say that, though, that is something that I considered. I take very seriously the culture and what happens in the department as far as how people are treated. And I think it's really important to treat people with respect and kindness. So I do believe that that is something that was on my mind as far as his conduct was concerned in making this determination.
And would you say that in the course of your role at Housing and Neighborhoods that you have shown respect and kindness to your employees?
Yes.
And isn't it true that one of your employees, in particular, Raina Nishimura, filed...
Objection to 160A, 168.
It's for purpose of impeachment.
I don't understand what the question would be if you're not going to invoke some part of this employee's record.
No.
So ask the question, but before you answer, I'll allow time for you to object and we can assess.
Okay. That she filed a complaint against you in regards to your treatment of her.
Objection to 160A, 168 personnel matters.
Yeah, I'm not going to allow that.
To Miss Emma Sutton's personnel record.
I'm not going to allow that.
So,
It's sustained.
okay. So have employees complained about the way that you've treated them?
To whom?
Objection again.
Your testimony is that you believe that at work people should treat each other with respect and kindness. And my question to you is, have you had complaints that you did not do that?
Same objection as to 160A, 168.
Well, I'm going to allow the general question without
naming the employee.
Has anyone complained to me about my treatment of them?
Complained about you?
No.
Are you sure about that?
Complained to me about the way that I'm treating them?
Complained about you.
Complained about my treatment. Does that feels? Can I answer that?
So ask the question again. I'll leave room, or before you answer, make sure that there's time for the city to object. Ask your question again.
So in your statement that you want at work people to treat each other with respect and kindness. And my question to you is do you have a knowledge of any complaints about you not treating people at work with respect and kindness?
Same objection as to 168-168.
Your Honor, she made the statement. She opened the door. I think we should be able to impeach her on that statement.
You can answer without, if you can answer without in any way invoking the personnel records of any city employee, you may answer. Yes.
If she should happen to answer that she knows about those, then that would be a violation because she's released information prohibited by law. It doesn't matter if it's impeachment or anything else.
Tom, speak up, please. We cannot hear you. And into the microphone.
No, I'm just saying, whether it's for impeachment or some other purpose, should she answer the question, yes, I've heard about complaints about me, that would be part of her personnel file, and therefore should not be able to open that to public.
And I guess that's assuming it would be a part of the personnel file. And so I'm going to do this. If you can answer the question without in any way referencing a personnel file or a report of something in a personnel file, you may answer, but otherwise you may not answer.
Yeah,
I'd like to clarify, including your own.
The question was really a yes or no question. It wasn't an expansion of names or anything like that.
But the instruction remains.
The question you asked me was, do I treat people with respect and kindness? And my answer was yes.
Okay, that wasn't my question.
I cannot speak about personnel matters. I mean,
So it's a yes or no question. It's not asking you about the names of any employees or this.
it's my
Objection as to 168-168, as has already been explained.
I think she's testified that she cannot answer the question without reference to her own personnel file or another.
She opened the door. She opened the door to her character.
Personnel files have not been released and pursuant to the Personnel Privacy Act cannot be discussed here without a release.
For purposes of impeachment, my objection, my argument stays the same.
The purpose is irrelevant.
I'm going to sustain the objection.
Okay.
Thank you.
You spoke about the hearing regarding Exhibit 31, and you indicated that Mr. Juarez didn't have any witnesses, but he did provide statements to you at that hearing with you during his grievance.
I don't recall that.
Okay. He gave you his response in regards to the statements? He read from a document?
I don't recall any documents being provided to me at that hearing.
Were you aware that the issue with Corbett, the demolition project of Duplex Village Set 1, was an ongoing issue that Mr. Juarez and his supervisor were trying to manage?
No, what I was made aware of was in February, and the information provided to me was then passed on to HR to do their investigation, and the information that was provided to me was that Mr. Juarez allowed a contractor to proceed with the demolition knowing that there were not the proper permits in place. That was my knowledge.
So you were not aware that Corbett did not have authorization to demo 2 duplexes at a time?
What I just stated was the entirety of my knowledge.
So you're saying you don't recall Mr. Juarez explaining to you that when they did that, it triggered a mass grading plan?
He could have provided that information, and I don't recall. However, knowing that now, it would not change my decision.
Did he explain to you that when they did that, that also resulted in erosion control fencing that would be required by the city?
I don't recall.
And were you aware that even though Corbett got paid, they weren't the ones to ultimately issue their permit?
No, I didn't. I was not aware.
So you weren't aware that their permit was issued a whole year later by another contractor?
No.
Were you aware that Mr. Corbett's company had been paid all of his previous invoices within 30 days?
No.
So the only information that you have is that you have one late payment to Corbett Demolition.
The information that I had was that Mr. Juarez allowed a contractor to proceed with the demolition knowing that the proper permits were not in place, and then subsequently withheld payment, and then subsequently was insubordinate.
The information that you received, that was through the HR investigative report, correct?
The totality of the information, yes, was provided in that report.
So you didn't talk to Hillary Leacock in regards to the situation?
I talked with Lamont Taylor, who was my direct report.
You did talk to Lamont Taylor. Okay. And did he let you know that he had been trying to manage the situation with Corbett's handling of the project?
The information that Mr. Taylor provided was what I've stated, which is that Mr. Juarez allowed a demolition to occur without the proper permitting and knowingly did so, that he subsequently denied payment or was withholding payment from a contractor, and then was insubordinate. Those are the facts that were provided to me by Mr. Taylor.
Did Mr. Taylor inform you who instructed Mr. Juarez to not issue the payment?
To not issue payment?
Mm-hmm.
No.
And again, he had already issued other payments. It was just that one payment that you're referring to.
Again, I had those three facts, and so that was the information that I was acting off of.
I'm going to direct your attention to stipulated Exhibit 19 that's located in the binder there.
Yes.
Okay. This is in regards to your email exchange with Mr. Juarez and with Dan Sargent in regards to 408 Bowling Court. And if I could direct your attention to the last page of that, page 3 of 3. And do you see Mr. Juarez's email Monday, January 29th at 12:33 to
Yes.
Dan? Okay. And Can you indicate in that email where he's being disrespectful?
I did not claim he was being disrespectful in this email.
Okay. In his email, he's just asking a few questions of the contractor, correct?
Correct.
And then on the next page, or going backwards through the email thread, Mr. Sargent tries to tell Mr. Juarez what his role is and informs him that this is a different type of program or contract, correct?
Correct.
And in response to Mr. Sargent, you reply and indicate about that's good information. And you should reimburse either way. Correct?
Where's the page? Where am I looking?
On that same page, it says 2 of 3 in the middle there.
Mm-hmm. Yes.
Okay. And then in response, Mr. Juarez chimes in on other concerns he noticed about the invoice as well. Is that correct?
Yes.
And he lets you know that the previous contractor for this program didn't have any concerns about the questions he asked about the invoices.
To my knowledge, this program is entirely new, so the contractor, the former contractor, was not a part of this program. And I think you can see I say perhaps more than once that I think Eric doesn't understand that this is a different program.
And when did this program begin?
I'm sorry, repeat your question. I didn't hear you.
When did this particular program begin?
I believe it was the fall of 2023. Council directed a program that would be flexible, and it would use local funds in order to be flexible, because the other 2 programs utilize federal funding, which can be limiting.
On the first page, page 1 of 3, it looks like Mr. Juarez's email actually begins at the bottom there, where he thanks you for the update.
That email goes on, yes.
Okay, and we actually already talked about that part of it, correct?
Okay, so thank you for the update is the first sentence of that email.
Right, and then we covered that other part already.
Where he was questioning again the instruction he was provided.
Well, he had said, like you said, thank you for the update. After I read Mr. Sargent's email, I started to wonder why he was coming off defensive, and or if he was instructed by someone else to tell me what I needed, right? Again, the city are paying a contractor, rebuilding together of Triangle for services, and transparency is a must. The other item I noticed on this particular home was the spending of testing for asbestos lead at a cost of $600. This home was constructed in the early 80s, which is past the asbestos lead period to test. The other contractor never had an issue with my questions.
That was an incorrect statement made by Mr. Juarez.
Which one?
About the asbestos testing.
Okay. And in response, you have a response there?
Yes, so I note on the second bullet down of my email on page 1, you're incorrect about the asbestos, as the EPA requires an asbestos survey prior to any reno or demo, regardless of date of construction.
And in this email, you say, I will not repeat myself on this topic, Eric. While I appreciate your thoroughness and concern for protecting the city's interest, you need to better understand your role and think more about how you communicate with RTT as well as with me. my prior email, there's no reason why you need to see prices for your inspection. Your COR's role is to sign off that yes, the work described in the scope of work was done, or no, it wasn't. And would you say that the tone of your email here is been given with respect and kindness?
Absolutely. I was being direct with a staff member.
After this email, that's when you initiated the investigation, correct?
What is the date of this email? They had the timing
This
was
is February
in
7th.
February, but they had absolutely nothing to do with each other. As Erica Brandt noted, and I will also note that these questions were in error. Mr. Juarez did not understand the program that he was administering to know that a washer dryer was not something that he needed to question. He also did not understand basic tenets from the EPA about asbestos testing requirements. This reflects a trend and a consistent issue with Mr. Juarez not understanding the basic tenets of city programs that he is overseeing and administering.
And Mr. Juarez disagreed with you on that issue, correct?
He was incorrect.
Dan Sargent, a rebuilding together of the Triangle, was this a new contractor to the city of Raleigh?
I don't know.
And had you worked with this contractor in your previous employment?
Yes, I have worked with Rebuilding Together Triangle in prior roles.
And did you make the connection for Rebuilding Together the Triangle to do contracts with the city of Raleigh?
No, I don't have anything to do with that process.
Were you aware that prior to the date of that email that Mr. Juarez reached out to his supervisor, Erica Brandt, for clarification regarding the washer dryer?
I don't believe I did.
I turn your attention to Exhibit 18. And it appears that this email that Mr. Juarez sent to Ms. Brandt, that she looped you in and you responded?
Yes, I was mistaken. Apparently, I did know 2 days prior to that other email.
Do you see in Mr. Juarez's email to Ms. Brandt that after the meeting that they had on the issue, he was even more confused on the topic?
Would you please repeat that? I'm sorry.
At the top of stipulated Exhibit 18, Mr. Juarez sent an email to Ms. Brandt letting her know that there was a meeting on this washer dryer issue, and he was now more confused after the meeting.
I see that. He
So
wrote that.
were you aware that there were communications that took place outside of just this email thread regarding that washer and dryer?
I don't know.
It looks like here he indicates there was a weekly rehab meeting on the issue, and there was a recording of that.
I attended, as the director of a more than 70-person organization with multiple divisions, it is a challenge and not something, I think at this time I was trying to prioritize attending all team meetings, but I do not recall being at a weekly rehab meeting where this was discussed.
But you see there in his email, he's saying the reason why he's writing again is because after the meeting, he's more confused now.
Where does he say he's more confused?
At the top of that page.
Oh, okay, yes. I wrote the email because he was more confused after the group had discussed the topic, which, to my understanding, part of the issue is that Eric was provided guidance several times and told several times that these purchases were allowed under the program because of the local funding utilized, and he would not stop bringing this up. And I think that also refers back to when I said I'm not going to repeat myself, because this had been told to him several times by the contractor, by me, by his direct supervisor, and by, it says here, Robin Reese, who also, I believe, was supervisor to his supervisor at the time.
Well, it looks like this email, though, happened 2 days prior to your email saying you're not going to repeat yourself on the issue. He's indicating there that he's confused because the meeting said something different.
I'm not aware of any other information provided to Mr. Juarez other than the program's policies and existing guidance and rules.
And you see that he's attempting to get clarification from his supervisor, Ms. Brandt.
He's going, well, I don't believe that Erica was his supervisor. So he is
in his chain of command,
reaching up the chain of command and sending a recording of a meeting and saying that the tone that Robin took is too much for him and the group, and it feels that she's talking down to you and will not let him speak. It feels like this is sort of about the tone of Robin, who I believe was his supervisor's supervisor. It doesn't refer to, let's see. Yeah, I don't know. What is the question again? I'm sorry.
Well, I think and are these recordings of these meetings, are they kept?
Not to my knowledge.
I have a question for clarification, please. I'm trying to follow the chain, but is page 1 of 2 of stipulated Exhibit 18, the very top part that you're referencing now, was that added on, or, because I don't see everybody that was in the original group, I only see Mr. Juarez and Ms. Brandt included in the email, so I don't know, is this a continuous chain, or was this added on to the end of the stuff below that? Do you know?
This was a document provided by the city in their response to the petition, the request for hearing.
Can the city answer that?
I believe this information was provided as public records request by Mr. Juarez. He made a public records request and a personnel records request, and so it would have been provided as part of that, where HR, the normal process is to ask IT to pull any emails And so I don't really know the answer to your question, except that whatever was provided to HR from IT is what he was provided.
Because I see the exhibit label at the bottom, like I said, I think this is a part of their response to the petition. And it looks like on the bottom, it says, "From Eric Juarez to Erica Brandt." And it's got the same subject line as the rest of the page. And on the other, he's saying, "Hi, welcome back, big question."
My understanding seems to be that after Ms. Sutton responded to the email from Mr. Juarez, he then forwarded it over to Ms. Brandt, if that.
So let's, if we can, you know, if there's a question for the witness, let's ask the question for the witness rather than speculate about.
Okay.
exhibit.
So,
And I want to say this, just, I want you to be aware of the time because we are coming close to, I don't know whether there's another witness for the city.
There's one more, and I can abbreviate my questions, but also I'm not really understanding the relevance of all of this.
Yeah, I do think we need to move on, and if we're going to have completion of this today, you know, we need, I'm not trying to cut you off, but I do think we need to move on.
yeah, I think that the document speaks for itself, so we can move on.
All right. Yeah. Yeah, go ahead.
So I have only one question. Subsequent to your perception of patronizing behavior by Mr. Juarez during the appeal hearing, do you feel, are you confident that you've maintained managerial objectivity?
I'm sorry, could you repeat the last part of that?
Are you confident that you have maintained managerial objectivity subsequent to that feeling?
Yes, sir.
Thank you.
Anything else, Ms. Lemons? Any redirect?
No, thank you.
Thank you, Ms. Sutton. Your next witness.
Thank you. I call Evan Raleigh.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you so much. That's the question I have.
Good afternoon. Please state your name and business address for the record.
Certainly. Good afternoon. I'm Evan Raleigh. Business address is 222 West Hargett Street, Raleigh, North Carolina.
Okay. What is your position with the city?
One of the assistant city managers.
And when did you start that position?
In April of 2021.
Okay. What are your duties as an assistant city manager?
So I have oversight responsibility for a portfolio of several departments, one of which is the Housing and Neighborhoods Department.
And as part of your portfolio, do you have responsibilities relating to personnel matters?
Yes.
Okay. And what are those responsibilities?
So I am usually the one of the presiding officers when grievances reach the manager's office level, which is my involvement in this case. I heard the grievance as once it reached the manager's office level of appeal, and I also have oversight responsibility for the department heads, personnel-related matters when the situation calls for it.
And did you conduct the grievance process under 300-18 in this matter?
Yes.
Okay. And what was the process that you followed for that?
So the process involved, I received kind of all of the investigatory documents that had preceded, which included the original appeal, received the report that had the investigatory report from the Human Resources Department. I received the notation and documentation from the department explaining the rationale behind their decision. And so took all of that information into consideration when forming, the information that came up as a part of the grievance hearing itself with Mr. Juarez. So combination of all of that is what led to my rendering of a final determination in the case.
Okay. And did you meet with Mr. Juarez?
Yes.
Okay. And what happened at that meeting?
So Mr. Juarez explained his position. He, I think, has, I think from his vantage point, explained what he believed, the reason for his actions. I think it was probably easiest to characterize it as, what you'd expect to hear in any typical grievance proceedings. He was presented with the rationale behind the department's issuance of discipline, and he responded with his perspective on that. And that basically, constituted the hearing.
Okay. And what did you decide?
So I determined that the department, I sustained and supported the department's determination in this case that Mr. Juarez's employment with the city should be terminated.
And what was the basis of that decision?
So for me, in reviewing the documents, I think there were, I always try to look at the fundamental questions at play. And so in this case, it appeared, based on all the competent evidence that was presented, that Mr. Juarez had knowingly issued a directive to a contractor to move forward with a demolition project without having secured the appropriate approvals and the permits to do so. Subsequent to that, it appeared that Mr. Juarez took steps to cover his tracks a bit, that he withheld payment from the contractor for work that he had authorized, and then was insubordinate in essentially defying a direct order from his assistant director to issue payment, which at that point was long overdue to the contractor. And so it felt very clearly to me, based on everything that I reviewed, that that the decision was warranted and something had, that there were very clear multiple compounding errors in judgment that had been made in this case.
I'd like you to turn to stipulated Exhibit 21, please. And that has been stipulated into evidence, and it appears to be a memo from you to Human Resources Director Charnel Jones. And the subject is Eric Juarez termination appeal determination. Why did you send that memo to Ms. Jones?
So I will say that while this memo is titled this way, this is, it was never actually, I never actually sent this memo. So this is, I have a practice of having essentially producing a memo to file that I can use to reference if questions come up, so that I can, accurately recall the basis under which my decisions on these kind of matters are made. So I titled it that way, but it was not actually delivered. So this just remained with me after I produced the document.
Okay, thank you for that clarification. Now, you list two contentions. The first one is contention 1 on the first page. The department asserted that Mr. Juarez knowingly and inappropriately issued a notice to proceed to Corbett Construction, a firm that had been hired to demolish city-owned property at 2000 Hawkins Drive. And so you did find that contention did occur, correct?
That's correct.
Okay, and what specific evidence did you consider in support of your contention?
So there were, in the case file, a series of exchanges, email exchanges that I think have been referenced throughout the proceedings today. one of which was from the contractor essentially asking Mr. Juarez, do I have permission to proceed? I think it's quoted here. I quoted it. It said that the contractor, let me find the exact quote. Yeah, so the contractor said, indicated in this email exchange that he submitted over a week ago a demolition request for a demolition permit, and it has been approved by a few departments, but not all, and proceeds to request permission of Mr. Juarez to proceed with demolition. And then the following day, Mr. Juarez says, yes, you can move forward.
Okay, and you heard some testimony from the petitioner's witness, one of the petitioner's witness, that moving forward with demolition schedule doesn't really mean to move forward with the demolition. Do you have experience with these contracts, construction contracts, as part of your job as an assistant city manager?
Yes, I'm typically not an administrator of these kinds of contracts. We have staff to do that, but I would say that is not a reasonable interpretation based on my knowledge.
Okay, and you actually signed off on this contract as on behalf of the city, correct?
Yes, I believe at this particular point in time, the department was out without a department head. We were the previous department head had just retired, so I was acting in an interim capacity at that time, and I believe this contract probably, based on the time, was signed by me.
And so, did you consider Mr. Juarez's response to be a notice to proceed as you understand it?
Yes.
And then contention 2 is the department asserted that Mr. Juarez attempted to cover up the inappropriate issuance of the notice to proceed to Corbett Construction by withholding payment for services rendered. And so can you just summarize your finding there?
Certainly. So, again, this was referenced previously in testimony, but what I keyed in on was that there was this exchange between Mr. Juarez and David Gray in the department after having been told by Mr. Taylor, former director, assistant director, hey, we are outside the bounds of city policy with respect to the timing upon which contractors should be paid when an invoice is sent. We need to get this contractor paid, particularly since this contractor had been paid for, or had performed work that he had been essentially instructed by Mr. Juarez to do so. And so seeing this exchange, knowing that, and seeing this exchange between Mr. Juarez and Mr. Gray, he's, indicating that that directive from Mr. Taylor, he characterized it as crazy, his email being crazy, was I think one of the clearest indications of insubordination that I've seen. So the appropriate response to that should have been, we need to get this done.
Did you consider a lesser disciplinary action than termination?
That's one of the things that I always think about, is does the punishment fit the crime? And I think in this case, I felt like the punishment did fit the crime because of what I would consider the aggregating factors. It was not only the initial misstep of knowingly issuing a notice to proceed to a contractor with the knowledge that that contractor didn't have all the permits to do the work. It was the subsequent step of evading the contractor, ignoring direct orders at the point at which that mistake had come to light in the department. So the compounding of the initial mistake and the risk that the compounding of that initial mistake, in my estimation, presented to the city, when taken together, certainly in my mind substantiated the action the department took.
And I apologize, but did you testify that you reviewed, did you review any the HR investigative summary?
Yes.
Okay. Let's go to stipulated exhibit 12. And towards the bottom of, where it says investigative summary, the second paragraph towards the bottom, that summary says that however they, presumably Mr. Juarez and his supervisor, decided not to pay and agreed that they would let him, if Corbett wanted to escalate the situation to the city manager. Corbett would then have to explain to the city manager what happened with the permits. Is that a reasonable way for an employee, a project manager of a contract to proceed if there's an invoice dispute, to just let the contractor go to the city manager? Is that your expectation as in the city manager's office?
Absolutely not.
Why not?
Our expectation is that, employees will appropriately handle the matters that are within their purview. And if they need assistance, they reach out. But to essentially absolve yourself of any responsibility in reaching a resolution and allowing a problem a problem to fester and allow to essentially blow up in a way that would present the city, position the city to be, at risk, or, essentially this ducking your head in the sand is absolutely not a behavior that we support or condone.
Based on your understanding of the city's disciplinary policy 300-14, was your termination decision based on sound and considered judgment?
Yes.
Okay, how so?
Well, again, just to go back to my statement earlier, what I often consider in terms of what discipline the department administers is it consistent with the nature of the facts that led to the discipline? Does the punishment fit the crime? I think that's the best way to say it. And so, in my estimation, again, yes, that this was a situation that was unusual, that clearly represented, in my review, a compounding of multiple mistakes. There were multiple opportunities for Mr. Juarez to take a different action, certainly ones that would not have put the city in a legal, at risk in some way. And even if there had been some contrition shown, or some acknowledgement, I think at any point that there had been mistakes made on his behalf that I think are really plain for a reasonable person to see, might have resulted in a different action, a different outcome. And so, in the absence of all of those things, I think, again, this is, in my mind, was an appropriate action.
Thank you. I have no further questions.
Ms. Lemons?
I have some questions for you. Sorry, it takes me a while, this little writing. I'm not as young as I used to be. Okay. So during the hearing, did you hear from any of Mr. Juarez's witnesses?
I don't recall there being any witnesses. I think it was just Mr. Juarez was by himself in the appeal.
And how was this appeal structured? Was it a meeting in your office? Was it in a conference room like this? How was that structured?
Yeah, the appeal hearing was in, if I recall, it was in our conference room that's located just down the hall here, adjacent to the manager's office.
I'm going to turn your attention to Exhibit 20. And you did have a chance, right, to look at these exhibits during your review prior to making your decision, correct?
Yes, I believe, I'm going to assume that most of what's represented here was in the appeal book, but I don't know that for certain. But
Exhibit 20.
20. Mm-hmm.
Mm-hmm. So on that third page there, and I think there's that screenshot there.
Mm-hmm.
And can you read that whole statement of the screenshot?
So the screenshot this is a message from Eric, or Mr. Warris, or David. It says, David just saw Lamont crazy email. We will not rush to Kim for a check for Corbett. Hillary will reply to Lamont in a few minutes. And then presumably this is David responding by saying, I already talked to payroll and they have agreed to submit it for payment on ACH on Monday.
So if payroll issued that payment on Monday, and if I can turn your direction, there should be some exhibits that say invoices.
Do you happen to have a number?
Oh, do you have them? Yeah, those are witness exhibits, I think. This has been previously labeled as Employee Exhibit 1.
Okay.
Okay. So on the second page of this exhibit, on the back there, do you see these invoices here to Corbett Clearing and Demolition LLC, I believe? Is that your understanding of the contractor regarding the permit issue, the payment issues that you've testified to?
Yes, this is the Corbett invoice, yes.
Yes.
This is the
Okay.
same contractor.
And do you see there on the bottom where it looks like they've received a payment of $9,800 prior to this invoice, and the balance due is $17,155? And do you see where it says paid on 11/2/23?
And the city's going to object to the handwritten portion of this document, as the document is not a city document or one that the city can acknowledge it ever received, at least as far as the handwritten portion of it. It should be made clear that that's Mr. Juarez's writing, not a city record.
That is Mr. Juarez's writing. So on the next page, do you see that invoice date 11/15/2023?
I do.
And you see there on the bottom where it says two payments, where it says payment reference number 813-664, invoice reference number 813-618.
Yes.
$9,800 looks like was paid.
Yes, I see that noted.
And it looks like that was the same payment, just listed again, the same payment that we saw on the previous invoice dated 10/26/23. Okay. And then below that, it says payment reference number 813-687, invoice reference number 813-619. And do you see where that payment number right there, or the amount is $17,155?
Yes.
So as of the date, at least, of this invoice, if we're not going to consider the writing on the bottom of the previous page, we know that at least by 11/15, that payment was credited to the account, so it was paid.
That appears to be the case, yes.
Okay. Additionally, it looks like there was another payment there on the bottom, again, in the handwriting, that looks like it was paid December 21st.
I see that, yes.
So based on the screenshot where he says, he can wait, we're not going to rush, it appears that several payments were made within or at least around that time of that screenshot.
Yes, so are you speaking to this, the December 21st payment? or the?
Correct. And then
Okay.
going back to the screenshot you were asked about in Exhibit 18, I believe it was? I'm sorry, 23? 20, my apologies. So in reference to that screenshot, it looks like Corbett was paid. We have invoices showing that he was paid. And then it looks like you said it was probably David saying, I already talked to payroll and they agreed to submit it for payment on Monday, right?
Yes, that's a yes.
So there's been a lot of testimony regarding concerns about Mr. Juarez, or with Mr. Juarez giving the term that's been used is notice to proceed, right, where he says proceed with a schedule. And yet there's concern about him withholding payments for them proceeding without that schedule. So at what point did the city consider the fact that he was attempting to force the contractor to abide by this contract in Exhibit 8 that you said that you signed on behalf of the city?
So I think one, and maybe I'm trying to fully understand your question. Could you restate your question?
So you testified, as well as the other witnesses for the city, that, and I'm just going by my notes here, okay? So if it comes out a little bit jumbled, I'm doing a little shorthand here. So your testimony was that if there's no permit, they shouldn't proceed. But on the other hand, you said that he was insubordinate in that chat by not issuing a payment, which appears that it was already issued. So at what point is the city consider the inconsistencies of the information that's provided to you by the city's witnesses?
I'm not certain that I agree with the characterization of inconsistencies. I think what was apparent to me in the fact pattern was that the first issue, which I think was, in my mind, not in dispute, was this request from the contractor to proceed with work to demolish the structures, to which Mr. Juarez replied, yes, go ahead. I think any reasonable person would have interpreted Mr. Juarez's reply to be an indication that they could proceed with the work, meaning in this case, demolish the structures. And in that communication, the contractor made clear that they're asking to go forward, but acknowledging at the same time that they haven't done all the procedural steps they need to do in order to perform that work in a way that's in accordance with the provisions of the contract, which Mr. Juarez was overseeing. So what I would have expected to see was Mr. Juarez not saying, yes, you can go forward, but saying, have you secured your permit? Or at the point at which the contractor said you hadn't secured his permit, say, no, you have to secure your permit first. As you know well, this is part of the terms of the contract. So I think that was clearly the first misstep. And then while it may be true that it shouldn't be paid, well, in a typical scenario, if unpermitted work is done, it shouldn't be paid. But this is a situation where we had an employee give a directive to a contractor. The reasonable expectation of that contractor would be to be paid in terms, in accordance with the provisions of the city policy and the contract, which is net 30. And so that's why I'm not really sure about the mischaracterization, but what's clear to me, I think, again, coming back to the basic tenets of the reason why this action was taken was because there were, in my mind, very clear errors in procedural steps and judgment on the part of Mr. Juarez that led to this confusing outcome here, and so, some agitation among the contractor about not being paid.
So it appears that we have differing testimony and conflicting testimony in regards to whether interpreting the statement in the email, and let's just assume that that was a notice to proceed. In that contract, only one building was supposed to be demolished at a time. And so a schedule, as he stated in his email, would have still been required. So assuming that that was a notice to proceed, it certainly wasn't a notice to proceed on all of the buildings, because in the contract it says it has to be done one at a time so that it doesn't trigger the mass grading plan. Would you agree that those were the terms of the contract?
I think that's the way the contract was structured, that the payments, the demolition and subsequent payments for that work would be issued in phases. But I think it's important to remember, at least it was not presented to me, after the point in time at which Mr. Juarez issued the notice to proceed, time passed, there was never any indication that he gave to the contractor that he was performing that work, regardless as to the scope of it, in error. I don't know that I saw any communication from him to the contractor saying, wait a minute, you're doing the wrong thing here. We gotta pump the brakes and reassess or take a different course. So I think that was also part of my concern, was that there didn't appear to be any acknowledgement by Mr. Juarez at any point after issuing that there was some understanding that the permit hadn't been issued, that there had been something, that he had done something in error by saying go ahead, and never alerting the contractor after doing that to say, hey, I made a mistake, or hey, you misinterpreted, anything like that I saw.
In this very, very thick contract, in the bid process, the contractor is supposed to submit their licensure and insurance and all of that, correct?
Yes.
So wouldn't the contractor know that they're supposed to have permits prior to demolishing the property?
Yes. I think the issue here, however, is it's Mr. Juarez's responsibility to assure that the terms of that contract have been met. And so while that is certainly true that our expectation is that the contractor, I think it's spelled out in the contract, secures the demolition permits, the appropriate permits, it's our expectation that the employee, the project manager, whoever is overseeing the project, has ensured that all of the provisions of the contract are being met and adhered to, which in my view didn't happen here.
In hearing your testimony and the testimony of the city's witnesses today, it seems like the city is expecting Mr. Juarez to take all of the accountability and responsibility when it appears that there were a lot of moving parts here. Is the city continuing to work with Corbett since this incident?
I'm unaware of what existing relationships we may have with that particular contractor.
I have no further questions at this time.
I have no further questions.
Thank you very much. I'm sorry, did you have a question? All right, any more witnesses?
No, Your Honor.
We have time, I think, for some brief closing statements, and I'll allow the city to go first.
Thank you, Your Honor. As Ms. Gross stated at the beginning of this hearing today, this is a very simple case.
if you brush aside the smoke and mirrors and the excuses, the lack of contrition, as Mr. Raleigh testified to, what happened here is on June 20th, 2023, Corbett Construction Company requested to demolish the buildings on New Bern Avenue, even though they didn't have the permits as required by the city's contract. On June 21st, 2023, Mr. Juarez told them to go ahead. Between that time and July 17, 2023, when Corbett submitted their first invoice for the work that had been performed, there was no payment until September 21st, 2023, despite numerous requests by Corbett through the emails that we reviewed with Mr. Juarez this morning, until September 21st, 2023. At that point, the only payment that was made was for Hawkins Street, which was the first demolition that did have the permits. But until Corbett Construction rang the alarm bell to upper management, they had still not been paid for the New Bern Avenue demolition. And it wasn't until then that they did receive some payment. And even then, Mr. Juarez did not want to pay them, as was shown by the team's message to David, directing David Gray not to send payment, because Lamont email is crazy. And so at every step of the way, as Mr. Raleigh said, had he shown some contrition, I made a mistake, we would not be here today. Mr. Juarez more than likely would still have a job. But the fact that he made a bad situation worse is what led to his termination. That alone and nothing else. Thank you.
Unfortunately, we weren't able to present the additional testimony that would have supported our justification without cause. Part of our case was that Mr. Juarez was discriminated against, that there was in a toxic environment, that witnesses would have testified to all of that, and that he was being retaliated against. Only thing that we're able to talk about are the items that the city listed in its write-up, investigation, and subsequent suspension. There were not any witnesses for Mr. Juarez that were interviewed during the HR investigation. All of the witnesses, folks that were interviewed, were the supervisors or folks in Mr. Juarez's chain of command. It's important to note that Mr. Juarez did have a supervisor, that everything that he did, his supervisor was looped in. In addition to that, his supervisor had a supervisor, and there were plenty of people in the chain of command. And what I'm seeing here today after listening for the testimony is that Mr. Juarez is being used as a scapegoat for everything that they don't like or that happened or whatever they don't like about the system or the way that it is. It's important to have people that challenge when folks are trying to get over on the government, and when contractors are trying to invoice for, say, $10,000 over what their contract price is, such as in the example of Corbett, as we saw in the documents. The issue with Corbett, and we have varying testimony on that, was that Mr. Juarez, his testimony is that he gave them the ability to set a schedule so that they could proceed. Even if you interpret him giving them permission to proceed, Corbett knew it was just one duplex at a time. And you heard the testimony of Ms. Nelson Donado that all the buildings ended up being demolished within a short period of time, which is inconsistent with the contract. Mr. Juarez attempted to hold them accountable by requesting the permits. And if you look at the emails that transpired between him and the Office of Corbett, checking on the status of the payments and the status of the permits, he stayed in constant communication with them and followed up to make sure that those were issued. And despite all of that, they still didn't issue the permit. They still didn't get the permit. The permit ended up having to be issued by another contractor a year later. This was a difficult contractor to deal with. He received a payment every month. Mr. Corbett sent these irate, nasty emails, even though he was getting paid every month. And the day after he received a payment of $17,000, he was fussing about the remaining 2% of $2,955. I'm sorry, $2,995. The RFP timing issue, I'm not going to get into that a lot because it happened in January of 2023. It wasn't documented in any of the, in the performance evaluation. It wasn't mentioned. There was no issue. And so I'm not going to get into, I think that his performance evaluation speaks for itself on that issue. The statement, again, that Mr. Juarez refused to issue payment is simply not true. He did initiate those payments, and even if he didn't have authority really to refuse the payments, because when he said, oh, he can wait a little bit for that last, we're not going to rush for this third payment, David's like, too late, we already issued it. It's done. So it's, at this point, it's a non-issue because Mr. Corbett has been paid for all of his invoices. The reason why he didn't get paid off of the July invoice is because he invoiced for all 3 properties, didn't have the permits, knew he was supposed to be doing 1 property at a time. They made concessions and said, okay, we'll pay you on the first one, because that first one had the permit. The first one, the payment was issued, the permit was issued, so they did that payment. So Mr. Juarez told him, sure, we'll make the payment, just do the invoice over for that property. Did that, got paid within a few days. Second invoice, submitted that, got paid within a few days. Third invoice, it looks like he was paid a little over 30 days. Okay?
I just want to caution you, we've got 5 minutes to
Okay.
have a discussion and make a vote. So
Got
if you
you.
would wrap up, please.
Yes, almost done. The other issue with this is that there was no progressive discipline. There was no written warnings. There was no disciplinary actions. It was just walk in today, you're on administrative leave, we're walking you out of here, and you never get to go back. You don't have access to your documents, your emails, anything to support your case. So at this point, we believe that Mr. Juarez's termination was unjustified. He should have had an opportunity to remedy or fix any of these omissions that they stated that he did. He could have been put on a performance improvement plan, but instead he was walked out of there and he was ultimately terminated.
Thank you so much. Any questions or discussion among the commissioners before we have a vote? And the question before the commission, the petitioner has the burden of showing that the dismissal was unjustified. Any discussions or questions or anything before we have a vote? All right. All the commissioners who believe that the petitioner met his burden of showing that the dismissal was unjustified can say aye. All right. Commissioners who believe that the petitioner did not meet his burden of showing an unjustified termination, say aye.
Aye.
So the petitioner did not meet his burden, and the hearing is ended for today. Thank you.
Oh, Your Honor, before we go off the record,
Yes.
did you want me to draft an order?
Yes. And please submit the order to Ms. Lemons for review, and whenever you communicate with me about the order, confirm that you have in fact gotten Ms. Lemons' comments, if any.
Thank you, Your Honor.
Thank you.
And I just want to make sure the stipulated exhibits are in the record. The stipulated exhibits, we will give you the exhibits to make sure they're in the record.
As well as the employee exhibit. Do you need a copy of that?
Ralph, do we have parking pass?
Your own, what you got out of the machine, you scanned in on the kiosk here, and that should get you out.
Thank you.
Before you go,
Yes.
in June, there will be a meeting with HR, with,
Just the policy.
it'll be just the policies, and there might be a long list of them,
It might be what?
a long list of them.
Okay.
More than 2 or 3, let's put it that way.
Do you know if we'll be able to get those before,
Thank you, Ms. Lemons.
as requested?
Juarez.
They're aware that to get them ahead of time, but there was just no way possible this time around.
Okay, did you have any others? Okay, we'll just put them in here then. It's all in here. Okay. Thank you, ma'am.
Yeah, we're going to, except for the and let me grab the city exhibits. We need to take the city exhibits out because those were not in evidence.
Yes.
So I don't want you to get confused. Here you go.